a change already. Some difficulty, Lordship. Can it be on the 16th of February, Lordship?
Okay. Yes,
I will take a consent of the other side, Lordship.
on the paper adjournment made on behalf of Mr. K. Chowdhury. This is the matter of 16th.
Obliged, Lordship.
Lordship, similar plain item number 29, your Lordship.
29. Same. Same order.
Lordship, I beg to item number 20, Manoj.
20.
20, Manoj. Instructions are awaited, Manoj. I have taken the consent of the petitioner also.
Okay, right. Mr.
D. Gogoi, Manoj. D. Gogoi.
D. Gogoi,
for the
Learned Counsel for the PNE.
PhD.
PhD. Submits that he has not received instructions with regard to whether the vehicle repair bills are admitted.
Manoj.
Accordingly, leave this matter on
16th, Lordship.
16th.
Obliged, Lordship. Obliged.
May I plead your lordship? I am paying for listing this content matter. This is 22 matters. So matter, affidavit has been already been filed by the respondent.
When?
Huh?
When?
When,
Do you want it listed?
Friday? Must apply.
Item number 43, my lord, we have filed a written objection that may be called from. Supplementary list item number 44.
May I please your lordship? I beg to mention for listening to read petition lordship. For motion lordship, already heard a case for motion lordship for 6th February lordship.
May I please, your lordship? Lordship, I beg to mention item number 14, lordship. With the concern of the petitioner, lordship. Can the matter after taken up 2 weeks, lordship? After 2 weeks.
You are for the petitioner.
Respondent number 1, lordship. Concern for the petitioner.
Who is the respondent number 1?
Respondent number 1, lordship. on
Who is the counsel?
Mr. N. Elixir.
Where is his Wakalat Nama?
Today filing. lordship.
Huh?
Today we'll file,
We'll
lordship.
file affidavit today. I mean, Wakalat Nama today.
Wakalatama, matter.
And you'll be filing your affidavit when?
Affidavit, no, lordship.
When will you file? How much time will you take?
After 2 weeks, lordship.
After, not before 2 weeks. After 2 weeks can be after 10 years also. What is the upper limit?
Lordship. 1 week, lordship.
Correct. Miss, what is your name?
B. Boysa.
Miss B. Baisha submits that. She may be given 2 weeks time to file affidavit in opposition. And states that Wakalat Nama on behalf of Mr. N. Singh, query for respondent number 1, will be filed during the course of the day. Accordingly, leave this matter after 2 weeks.
Lordship, I beg to mention WPC number 6989 2023 admission matter on the day after tomorrow. That is on 31st January, the day after tomorrow.
I'm not coming to court tomorrow, day after tomorrow. I'm not coming. You can come alone. We'll fix it day after tomorrow. I'm not coming.
Oh, acha. Next week,
Next week.
next week.
My please, your lordship. Should I beg to mention one thing on admission matters, my lord. On 8th, my lord. I'm on.
May I please your lordship, I try to mention item number 21 of the daily list. With the concern of the other side, I am seeking adjournment for filing affidavit in reply. Item 21. Lordship, 2 weeks time will be granted.
You're for whom?
Petitioner.
Who's for the other side?
BPC.
Yes, who's for the other side?
Given number. Item number 21.
21. Termination of that VCDC.
Lordship, I am appearing on behalf of the standing council.
for PNID department.
So he wants adjournment.
Lordship, we have no objection.
You want to file what? A reply affidavit?
Yes.
Mr.
A Thakuria.
A.
A Thakuria.
Thakuria appearing on behalf of Mr.
DP Mondal.
DP Mandal, counsel for the petitioner is granted. How much time?
2 weeks time.
2 weeks time to file reply affidavit. This is the matter.
Highly would like.
No, please, Your Lordship. Because I appear in item number 17 for the respondents, my lord. Sir, today, my lord, I have a small problem whether this matter will be taken up on any other date, my lord.
Yes, why?
On 12th or 13th, my lord.
On the prayer for adjournment made by Mr.
G. Chaudhary,
G. Chaudhary, senior counsel for the
respondent,
respond number,
private respondent number 7.
private respond number 7. Who is for the petitioner?
I'll inform you. I have not seen him in court, my lord. I'll inform him, my lord.
This is the matter on
12th or 13th, my lord, as your lordship pleases, my lord.
that calendar is so far away, I can't see. It's not blocking. Sir,
I'm with them.
yeah, have you filed affidavit?
Yes, sir.
Have you filed?
Nothing is ready.
It's ready, but they have not filed.
No, they are fine.
They have filed.
Lordship, if you mention item number, item number 6, Lordship.
Yeah.
Lordship, there has been some defects that needs to be rectified, Lordship, and apart from that, some more respondent needs to be impeded. So Lordship may allow us to withdraw with liberty to file afresh.
Mr.
NZ Chaudhary.
NZ Chaudhary, the counsel for the petitioner, prays that he may be allowed to withdraw the petition with liberty to file afresh. Next, who appears for the other side? Health. SC Health.
Yes, Lord.
Who is SC Health? Correct. The no one appears for the health department. Prayers allowed, writ petitioner dismissed as withdrawn, with liberty as paid for.
Watch out.
I beg to, I may be allowed to move on petition for admission hearing. Lordship. In last 2 occasions, it remained left over. So at any date on the first week of the February.
We'll see. First week, not possible. Second week. Apply.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention out item number 12, Lordship. The matter may kindly be adjourned, Lordship. As the senior is out of station,
Appointment of arbitrator, what is that?
Lordship, my senior is out of station. So any date may be fixed, Lordship. I expect.
My lord, on 20th February.
Right.
Different.
When do you want it?
Lordship,
On the prayer for adjournment made on behalf of the
after 1 week, Lordship.
petitioner's counsel. This is the matter in the next week.
Lordship. Next week. Lordship, item number 13. Lordship, I have to.
Why, what is this? Just give me item 12. Where is he? Where is the senior?
He went to Patna, Lordship.
Oh, how it's this, this is the matter. When is he coming back?
Lordship, on the 4th.
4th.
Yes.
This is the matter on 5th.
In respect of item number 13, 2 weeks time may be granted for filing reply,
What reply?
a reply to the affidavit in opposition.
Why?
There is some requirement.
Why, what is the requirement? You tell me. What is the requirement? This is appointment of arbitrator. What is the requirement? You want the appointment of an arbitrator. Then-
Want appointment, but
So what is their objection to that?
Lordship, my senior, he
5th. Where is your senior?
went to
Same
Patna.
senior.
I was same.
Same senior. List the matter on 5th.
Okay.
In the meantime, any affidavit that needs to be filed by the petitioner should be filed. By fifth.
Like,
Yeah, this matter relates to my non-payment of my vehicle hire,
Where is the admission?
my which I have annexed earlier last occasion, my we have filed, normally the office of the respondent number 6, kindly.
Mr. Council, there's an order of this court.
That is true, we have filed, that I'm doing, we have filed an application RTI and also representation asking to give it that document with seal signature, I've been informed by the respondent number 6, let the instruction, for the ends of justice, all the, my landed can will agree, all the bills is also pending in the other court today itself, after asking instruction, they have filed affidavit admitting this, if they denied it, it will be automatically dismissed,
Yes,
for the ends of justice, let the instruction.
Otherwise, we know otherwise it's a judicial order is there also.
That is true. That is true.
but you take a decision whether it's an admitted amount or not.
Yes, That's
Issue
let them
notice would
take-
come with
yes, yes.
instruction.
Huh?
Issue
Yes.
notice, Lordship.
Why? Why? You obtain instructions without issuing notice.
That can also be.
It's a small thing. It is
Yeah.
either you admit or don't admit, that's all. Mr.
Here go, Lordship.
K. Gogoi. Learned counsel for
All the respondents.
the respondent. Submits that he will obtain instructions as to whether the claimed amount for hiring of vehicles is admitted by the respondents. When do we list?
Especially respondent number 6.
Uh,
Because
especially from respondent number 6. Yes, when do we list it?
My lord, after 3 weeks, Lordship. It's from Pujai, Lordship. They have to verify also, Lordship.
List the matter on 19th.
highlight.
so this is an application for appointment of.
List the matter on 5th. That is senior company.
These are lordship, a tender for market was issued, lordship. Lordship, thereafter, lordship, the petitioner was also a participant. Lordship, however, the market was settled in favor of the respondent number 6. Lordship, because lordship, the name of the respondent number 6 was not present in the initial comparative statement. Later on, a new comparative statement was published, therein the name was present. Lordship, thereafter, lordship, the petitioner, through RTI, got the documents. Therein, lordship, the petitioner found out that the respondent number 6 had submitted 2 tender forms amounting to giving 2 different values. Lordship, if your lordship may be pleased, lordship, to come to page number 51, lordship. 51, and the translated portion is at page number 49, lordship. This is one of the forms submitted by the respondent number 6. Lordship, here, if your lordship may see, lordship, the amount is rupees 99,999.99 paise. And here, lordship, security deposit amount, where the bank draft number is 029034 dated 6/6/2022, lordship. This is one of the forms. Thereafter, lordship, if your lordship may be pleased to come to page number 56, lordship. 56, and translated portion is at page number 54, lordship. Here, lordship, same market, value is 2,92,000 and draft number is same, 029034 dated 6/6/2022, lordship. Same market, 2 different forms were submitted, as well as lordship, in the first form, that is at page 51, there's a lordship, it is very clear that there's a manipulation of the amount, lordship. From here, lordship, in the vernacular, lordship, here, if you can, lordship, in this portion, lordship,
Yes.
it is very clear that there is manipulation and overwriting, lordship, which is a fraud, lordship. Therefore, lordship, submission is that this is a very fraudulent,
So was your bid also considered?
lordship, I am the second highest bidder, lordship.
How much is your bid?
Lordship 99,000,
99,000?
99,000 Lordship in page number 32. 99,999 Lordship.
So same as this.
Lordship, the response number 6 was 99,900.99 paise. And the other value is 2,92,000 Lordship.
At a 0.99%.
Lordship.
So it's higher. So he has been awarded the market,
Lordship for 2,92,000.
2,90,000.
But Lordship, but he submitted 2 bids and one of them there's a Lordship, there's a clear overwriting also, Lordship, which Lordship renders it, this is a fraud on the part of the Lordship response number 6. Lordship, therefore I pray that there should be a stay, Lordship, in on the work order, Lordship. Clear case of fraud.
Public
I don't know,
interest is-
huh?
Public interest is involved, my lord. Market is already going
But Lordship,
past,
fraudulent
since 6 months is
submission.
over.
Huh?
6 months almost.
The period is from which period to which year?
Work order
Up
was
to 30th
issued,
June, my
Lordship,
30th
work order
June.
was issued on 23/11, Lordship.
23/11.
2023, Lordship.
And where is the work order?
Lordship at page 40.
Lordship may issue notice, my lord. I will place the record as soon as possible. my lord.
Lordship, but
That
till
is-
the next day, Lordship may stay the proceeding. Lordship may,
Stay,
Lordship, the response number
but
six
the
will be
market-
allowed to continue even for a single day, Lordship.
It's a public market.
But
my lord.
Lordship, this is a fraud, Lordship, prima facie fraud, Lordship. It should be, Lordship, declared border when initiating, in fact, Lordship.
But then his bid is higher than you.
Yes, my lord.
But Lordship, if the bid is not valid, Lordship, if it is a fraud on the part, he should be, Lordship, ousted, Lordship. Lordship, in fact, the second highest bidder should be allowed to run the market, Lordship, for the time being. Whatever initial, Lordship, clear case of fraud.
How do we know? Let them,
But then Lordship, till the next returnable date, Lordship may give a short date, Lordship may stay the proceeding, Lordship.
That will hamper the public, my lord, at large.
But Lordship, how can
yeah,
a,
yeah, for the private.
Lordship, how can a fraudulent
Huh?
person be allowed?
Oh, very good. Yeah.
running.
So, yes, why did you submit 2 bids?
No, my lord, I have submitted one bid. My bid value is about 2,92,000.
But
It's
Lordship,
disputed
from the
my
RTA
lord. I have not
documents,
submitted to tender, my lord. Submitted one.
When can you bring the record?
Record by 2 weeks, my lord.
Not 2 weeks. 2 weeks, then stay.
Then 10 days, my lord.
1 week.
I'll
bring
try
it
my
next
best.
week.
I'll try my best, man.
Otherwise, I'm staying it right now.
Next week.
Next week.
And one more private responding also there, my lord. Because they made an officer also party.
Lordship, an FIR was filed against that officer,
has to
Lordship,
go
because
to
it was in collision with that officer, Lordship, that the tender.
That is a
version
different
six
issue.
was
Yeah,
there.
we'll have to see the records.
My lord.
These are questions of fact, madam.
Yes, that is the problem.
Now, I don't know from where you got those documents.
Lordship from RTA, Lordship,
Huh? Okay.
RTA, Lordship, we have annexed the RTA
The form.
reply also, Lordship, at
Okay.
page number, Lordship, 45 and 47, Lordship. Initially, Lordship, the Ansari Panchayat refused to give because it pertains to Zilla Parishad. Thereafter, page number 47, Lordship, the forwarding, Lordship.
It's not article 45, 46. It is related to only on the.
Huh?
So, Lordship, page number 47 to the Public Information Officer, Dorong Zilla Parishad, Lordship.
Okay, right. Heard Miss R. Barwa,
Lordship, P. Barwa.
P. Barwa, learned counsel for the petition. So submits that she was the second highest bidder. For settlement of the market, settlement of the market
Lordship.
for the year 2023-24. That is from 1/7/2023 to 30/6/2024. As she had submitted a bid price of rupees 99,999. However, the market was settled with the respondent number 6 at the rate of rupees 2
2,92,000, Lordship.
2 lakh
92,000.
92,000. The petitioners counsel submits that the petitioner had submitted two bids. One for 99.999, and the other for rupees 2,92,000. By enclosing the same set of earnest money,
Lordship,
is-
same bank draft number, Lordship.
same bank draft number, page,
Lordship, one is at page 51, Lordship.
same bank draft number,
Lordship, bank.
029034, dated 6/6/2020. For both the bids. As a fraud has been committed by the respondent number 6, the settlement made in his favor should be cancelled. Mr.
Yes, Doctor.
S. Datta appears for
PNRD department, my lord.
the PNRD department, while Mr.
P. Raman.
P. Raman appears for the respondent number 6. Issue notice to the respondent number 7.
My lord, I can't appear for 2 and 4 also because it's represented by president, my lord. I can't appear for president.
Okay, issue notice to the respondents number 2, 4,
4
and
and 7.
2, 4, 7. Petitioner takes steps for service of notice on them by registered post daily within 2 days. What about Dusty?
Lordship, Lordship, Lordship will do dusty service also, Lordship.
In addition to the above, the petitioner shall take steps for service of Dusty notice. For service of notice by the Dusty service on the respondents number 2, 4, and 7. And file affidavit of service. Full stop. List the matter on 6th February. 5th February. 5th February.
At least 6 or 7, my lord.
Why?
One Monday I required, my lord, for
You do it on Friday.
my lord.
You do it on Friday.
If possible, my lord, 6 or 7, my
You do it on Friday. This is the matter on 7th. That is the matter on 5th. To enable Mr. F. Datta to bring the official records. Full stop. It is made clear that if no records are brought on that date, the question of stay of the settlement of the market will be taken up on the next day.
Lordship, Lordship, in page number 16, Lordship, in the interim prayer, Lordship, I may be allowed to correct, Lordship. It should have been read as to stay, but Lordship, inadvertently due to typo.
Leave it. It's a long process.
For that, they have to file IA.
They're going to file IA, then they're going to file amended. Well, otherwise the CIS will not take it,
Yes.
will not accept it.
All right.
May I please alone? Lordship, matter pertaining to non-payment of contractual bill made.
Huh?
Non-payment of contractual bill made. Liability statement is at page number 14, madam.
Page number 14.
Part payment has already been made, madam.
Balance amount 5
5 lakhs 40.
Actually, I am for water resource department. Now, let me take instruction, your lordship. Lordship, may issue notice.
No, what instruction will you take?
Lordship, whether there are some work which are there are two shares. Some share is from central government, your lordship. I do not know whether her petitioner's work is in that category or not. So I have to take instruction.
So how long will it take?
Lordship, kindly give me 2 weeks.
I'll give you next week. This is a small thing.
Yes, your lord.
Let her obtain instruction, madam.
Madam,
Right, Miss S. Yeah.
madam, may dispose it of my lord as per term sharing, madam. They verify, madam.
No, your lordship.
They have already admitted, madam, in page number 14, madam.
For
It is issued by my lord executive engineer, Guwahati East Water Resource Division, and a work order were also issued by the executive engineer, madam.
Lordship, may give some short time, your lordship. I'll take instruction.
This is
Page
the work
number-
order.
Page number 12, madam.
Madam, you have asked for the work to be done. You can't stop the payment.
That's true, Your Lordship.
How can you take that plea that now central government is not giving me money? That's your problem.
If the work relates to FMP, Your Lordship, plant management, then Dal Shakti Center, Dal Shakti Union of India is the necessary party here. That's why I want to take instruction, Your Lordship.
Okay, when?
For the next week, Your Lordship, short date.
Monday, madam. Mrs. S. Pritya, Learned Counsel for the petitioner submits that the petitioner has still to be paid the balance amount of rupees 540,707 for the contract work in terms of the letter dated 22/11/22 issued by the respondent number
Oh, my God.
3. Miss
Ardeka.
Ardeka,
For
Standing Counsel, Water Resource
and
Department,
for on behalf of Mr. R.M. Das, Your Lordship.
appearing on behalf of Mr. R.M. Das. Oh, she was Water Resource earlier. Ah. Yes, please for time to obtain instructions as to whether the contract was done under the
Plant management program, FMP work.
plan management
Program.
program, for which the central government would be a necessary party.
Yes.
Leave the matter on fifth.
That's one extra copy. Madam, I oblige.
Yeah, Your Lordship, matter pertains to non-payment of contractor bills, Lordship.
What contract was it?
Lordship, it's page number 12 is the RTI reply, Lordship. Liability statement,
Road.
Lordship.
Where is the admission?
Lordship, page number 12 is the liability statement, RTI reply, Lordship, where they have admitted there's two work order, Lordship. Report submitted, this is number 2 and 3, Lordship.
No, how much are they still to pay you?
Lordship, this is the amount, 57 lakhs, Lordship. 57 lakhs, 67,232. And there's another bill, Lordship, that is 4,20,000. It's a liability statement filed by the Assistant Executive Engineer, Road Department.
Yes.
This is only a running bill, Lordship. That is not yet sanctioned by the.
Whether it's a running bill or not, it's a bill.
Yes, that is there.
That bill has been prepared after measurement.
Yes.
Yes.
But so far as that amount is concerned, Lordship, in the RTI reply, that amount is not mentioned. Only the bill has been referred.
So, but this is the admitted amount, liability statement. That's what it has been stated.
No liability.
Liability
no.
statement, liability means what?
In my understanding, Lordship, so far as admission is concerned, Lordship, it has to come from the chief engineer, Lordship, not from the assistant executive. That is
Lordship, we
considered.
applied
No,
RTI and
chief engineer will not do anything.
Structurally-
You see, you see, the bills are made by the assistant engineer. And then it's approved and goes right to the top. It doesn't come from the top down. They don't do the work of a junior engineer.
I'm only submitting from, in view of the considerable adjustment, Lordship, there the admissibility certificate should come from the chief engineer. That is what I'm saying. Lordship will issue notice.
Lordship already admitted the amount, Lordship, and it's
But this is not admission, Lordship. This is only an
liability
RTI
statement, RTI reply, Lordship.
RTI reply cannot be accepted as an admissibility certificate.
No. This is, you have admitted. Liability statement will copy. You cannot twist this. We'll give you 1 week to obtain instruction. You obtain instructions. And if you don't, then we will dispose of this matter the next week. Monday.
In that case also, Lordship will dispose of this matter in terms of Kamsirali, Lordship. There also, Lordship, admission from the head of the department is necessary, Lordship.
Then you verify and pay whatever is the admitted amount. Because this is road construction.
Yeah.
This is not any central government scheme or.
My understanding is, Lordship, even if this matter is to be disposal of this matter in terms of Kamsirali, the admission by the head of the department,
So we will direct that the head of the department will verify.
without that verification, Lordship cannot dispose of this matter.
I
That is
can.
what I'm
We
saying.
can go in appeal. There's no bar.
This is the first day, Lordship. Lordship will issue notice in the meantime.
No, I'm not issuing notice. I'll do my job, you can do your job. I'm asking you, you can obtain instructions from the chief engineer with regard to this claim. Now, if you're not willing to do that, then I'll have to pass order. So I'm directing you to obtain instructions from the chief engineer as to whether her claim of this liability is correct or not. Simple. Miss K.K. Chaudhary, learned counsel for the petitioner, submits that in terms of the letter dated 19/12/2023 issued by the respondent number issued by the respondent number 5. The respondents have to have admitted the liability of rupees 57,67,232 in respect of bill number RA/1/RTRSD/NSRD/15 dated 11/2/2020 and rupees 4,20,037 in respect of bill number RA/11/RTRSD/NSRD/50-A dated 17/7/2020. That is at page 12. Huh? She accordingly prays that the respondent should pay the admitted liability amount. So, sir, Mr. P. Nayak, learned counsel for the PWD, submits that the admission of the amount would have to be made by the head of department, which in this case would be the chief engineer, PWD, bracket road, SI, who is the respondent number 2. Okay. In view of the submission made by Mr. P. Nayak, he shall obtain instruction from the respondent number 2 whether the liability reflected in the letter dated 19/12/2023 issued by the respondent number 5 is an admitted amount. This is the matter on 5. To stop. In the event no instruction is forthcoming on the said date, this court may dispose of the matter on the basis of the materials on the court.
Please.
Yes.
Yes, Your Honor, I'm a MSME unit. I'm a registered MSME unit. And what has happened is that I have entered into a dispute with one of my buyers.
You have entered into a dispute.
Unfortunately, Your Honor, because of non-payment of my bills.
Oh, okay. So you say a dispute has arisen.
The dispute has arisen, Your Honor, because of non-payment of my bills. And those disputes now I seek to resolve through the MSME Facilitation Council. There's a procedure set out under Chapter 5. I filed my reference in the month of August 2020.
It is with regard to what? What work are you doing?
Your Honor, this is transportation. Transportation of certain poles has taken place. And
Through the railways.
not, Your Honor, not railways. It's, I think, through the trucks itself. the trucks itself. So there's the outstanding. I'm claiming certain things, the other side is also claiming certain things. I put the document, but the dispute itself is not germane here. What's germane here is, Your Honor, the facilitation council is not, I think, operational because I've not been given a date.
So Lordship, I'll take an instruction on this because the council is there, it is in
It
existence,
is
that I know.
section 18.
Yes, Your Honor.
So I'll take an instruction on what is happening, like why it has been acted upon.
Okay, right. Heard, Mr.
Didas.
Didas, learned counsel for the petitioner, who submits that a dispute has arisen between the petitioner and
R3.
respondent number 3 on account, in respect of the bills to be paid as straight charges. He submits that though an application had been made for referring the matter to the what council?
MSE
Facilitation
Facilitation Council.
Council under section 18
18.
of the Micro, Small, Medium Enterprises Development Act. Correct?
Yes.
2006.
6.
Address to whom?
It'll be to the Facilitation Council itself.
Address to the Facilitation Council, the Facilitation Council has not taken up the matter till date. Mr. A. Kalita, learned counsel for the
Respond number 1 and 2. Lordship.
request number 1 and 2, submit that he will obtain instructions as to why the Facilitation Council has not taken up the application submitted by the petitioner. Accordingly, release this matter on 5th.
After 9th, Lordship.
Why?
I have to, I'll be out of station for a couple of days, Lordship. 9th or 10th, any dates,
Release the matter on 9th.
9th.
Obliged, Your Honor.
Wait, this is regarding shifting of an IMFL offshore from Dhubri, this town, to Halapura Gaon Panchayat. I have raised some objection regarding the shifting because the chosen location is in a prohibited area.
This is a prohibited area.
Prohibited area under the statute under 289. And IMFL offshore.
Is a but then I think in your
Restricted.
petition,
Basically, it's a restricted area as per the rule 289.
Mr. Council,
It is within.
Mr.
Yes,
Council,
my lord.
in your petition,
Yes.
you have said that there already exists a shop.
Yes, my
Then,
lord.
then if it's a prohibited area,
Restricted area under rule 289. Because.
so is there a difference between the word prohibited and restricted?
Well, restricted under rule 289. Because there are some distance criteria.
So is there a difference between the words prohibited?
Otherwise not, there is no difference, my lord. But what I am trying to impress upon your lordship that it is not within the ambit of rule 289. As per rule 289, to establish an IMFL shop, it has to be more than 150 meters from a school, my lord. Here, the proposed location is within 150 meters from the school and 100 meters from the national highway. But the
Yeah.
existing shop, it is beyond 150 meters and 100 meters.
Where is your representation?
Yes, madam. The school authority submitted an representative on 23.
Are you the school authority?
I'm not the school authority.
Is this a?
Yes, but I have also submitted. Madam.
Let us see your representation.
My is 24, madam.
Sorry. The 150, that issue has not been taken up by you.
But in the school, madam, it has.
Let them come. Let them come. Who are you? Have they authorized you?
No, madam. Authorization is not required under the rules.
Okay,
madam.
right. Heard, Mr.
Madam, kindly appreciate one thing, madam. There is a provision for raising complaint in the rules, my lord.
So you raise it to them. Let it be decided by them. Let it be decided by them.
That can be done, madam. I'm not objecting. I'm not objecting to that, my lord.
Whether you object or not, that's the only way out. Because you don't have any right to speak of a representation written by the school authority when you're not representing the school authority. This is not a PIL.
No.
If it's a PIL, I understand.
In case of IMFL liquor shop, my lord, anyone can raise an objection within the vicinity, my lord.
If you've got a reason, if you've got a good reason,
Yes, my lord, this is a good reason.
what is
Because,
what is the
because my lord,
reason?
kindly see the rule 289.
No,
Rule
just
289 is,
Ah,
in
what-
fact, 289 is specific, my lord. A one shop can be established within beyond 150 meters from a school
Mr.
or 100
Counsel,
meters from a.
I agree with that.
In-
But your representation does not say that. Your representation does not say that.
My representation says that
Say
there is
that they-
already an
That's
existing
what.
IMFL shop and there is no
Correct.
requirement.
Now
to
let,
develop.
there's no,
And
now
secondly-
let me ask
secondly-
you, let me ask you a
Yes, sir.
question. Can there be two wine shops in one locality or not?
Yes, if it is the beyond 150 meters from school and 150 meters from religious places and 100 meters from national highway, my lord, that can be established. And in between two wine shop, there is a requirement of certain distance, my lord, to maintain some distance. That can be done. my
But
lord.
your representation, don't talk about others.
Yes.
You have to stand on your own 2 feet.
Yes, my lord.
As per your representation, what is your ground for challenging the bringing of this wine shop to this wine shop to this locality? What is your ground?
I am simply saying that there is already in one shop, there is no requirement to have another one shop because rule 279 also.
So let them decide that. Only on that ground. Right. Show me the rules.
Yes, madam.
Heard Mr. N.J. Khatane, learned counsel for the petitioner, who submits that the petitioner has written a letter dated 13/12/2023 to the respondent number 2 with a request not to shift the IMFL off shop, off OFF shop from Dubri town to Halakpura Bazaar under Halakpura GP as the Halakpura Bazaar area already has two IMFL shops and the move to shift another IMFL shop to the Halakpura Bazaar area is not acceptable to the residents of Halakpura. He further submits that the proposal to shift the IMFL off shop from Dubri to the Halakpura Bazaar area is in violation of
289, madam.
Rule 289 of the Assam Excise Rule 2016. He submits that the writ petition can be disposed of if the petitioner's representation dated 13/12/2023.
Yes. Sorry, madam.
Third, it
Yes,
can
yes,
be
sir.
13/12/2023 is decided by the respondent number
3.
3. Mr.
And sir,
N. Goswami appears for
1, 2, and 4.
1, 2, and 4. While Mr. K. Gogoi appears for respondent number 3. They submit that they have got no objection to the prayer made by the petitioner's counsel. in view of the fact that the issue raised by the petitioner's counsel pertains to disputed questions of fact, the respondent number 3 is directed to. No, respondent number 3 is directed to examine the petitioner's representation dated 13/12/2023. Bracket annexure C, and dispose of the same within a period of 1 month from the date of receipt of a certified copy of this order, along with a copy of the petition.
Till disposal, not to settlement. No.
The decision taken should be communicated to the petition.
But
We do not know.
till disposal, not to settlement.
Otherwise, it can be, you can decide in a shorter period, not
Yes,
1 month.
that can also be done, my lord.
Decide within how much time?
15 days from the disposal.
Within 15 days from the date of receipt of a certified copy. So
Not to, till, not to, no. Oblige, lordship.
The petitioner also will raise that farm losses because of some financial difficulties.
Huh?
Because of some financial difficulties, losses because of default by 2 organizations losses. Now also the ETF authority has determined the liabilities to rupees 30,78,361.
How much?
30,78,361. 30,78,361.
361.
30 lakhs.
Tell it that.
30,78,361.
Yes.
And till lordship, December lordship, we have paid 12,69,959.
12 lakhs?
12,69,959.
So you have defaulted the payments.
Payment lordship.
Then you have got to pay.
Yes, we will pay lordship.
Then
As per installment lordship, because there was an agreement on 9.
you have to pay within the, you have got to correct
Yes.
the non-payment issue.
Lordship, on 19/5, lordship, a settlement was arrived.
How much are you supposed to pay as on date?
Lordship, that settlement is that we are supposed to pay 1,53,000.
No, that is a different thing.
Lordship,
As on today,
lordship.
how much were you supposed to pay?
This is the amount due, lordship, 30,70,000.
As on today?
Lordship.
And you pay that amount?
Yes, we will pay lordship.
When?
And in terms of the installment lordship,
No.
1,53,000.
No.
They've agreed. Lordship.
I don't know. If they agree, that's a different. If they don't agree, sorry.
19/5 lordship, may kindly see lordship. 19/5, page 24 lordship.
Page?
Page 24.
Yes.
Lordship, this is the letter issued by the EPF authority. Lordship. We hereby undertake to the following and repayment to you to grant 26 numbers of installment to repay your dues. The facility of installment shall be available to both unexempted and as well exempted installment. And the amount has been revolving guarantee also we have already submitted. We have also submitted post dated 6. And
You see, that is your proposal. If they
No.
accept, that's a different issue.
Lordship, may kindly say 9/5 lordship. That is this is in terms of order dated page 19 lordship. Page 19 lordship.
Okay.
Page 19, 19. Annexure 4.
Yes.
Grant of installment facility in respect of Messrs. Nehar's port number so and so, so and so. They have agreed that this 30 lakh amount lordship will be divided into 25 installments and it comes to around rupees 1,53,993. And we are paying till December lordship, we are paying. And that check should be
You see, Mr. Council, this was done where? Where was the installment?
Yeah.
Facility was allowed in which year?
in May 2023.
23.
No.
Is it not before that?
No. And also in terms of
So you were supposed to pay how much?
30 lakhs, that amount also I already said also.
And you're supposed to pay 1 point?
1,53,993 also.
Every month
Every month also.
from
From May.
From May of 23.
Initially, we paid an amount of rupees 5 lakhs, then this agreement was done. Then on 17th Feb, they again asked us to submit the revolving bank guarantee.
No, so from May 23,
That's it.
you have continued to pay this 1,53,000?
Yes, that's it.
You continue to pay?
Yes, we have till now, let's say December, we have paid 12,69,959. They have
Okay,
admitted December.
then yes.
Lordship, as per my instruction, Lordship, the first check which they have issued to me, that was dishonored.
Oh,
And what they are saying in facts, Lordship, there are lots of dishonorities in their facts. And Lordship, one letter was issued from the.
okay.
That this
Lordship,
first agreement already
I just
cancelled.
clarify also.
There's nothing to clarify.
Yes,
If you are dishonored, then you have
The
dishonored.
first check was presented after 15. That is why, Lordship,
Lordship, these letter is saying that the agreement which was made on 09/05, that was cancelled, Lordship.
only
Yes.
only on one occasion, Lordship. Because
Except-
that was presented after 15th of the month, Lordship. They were supposed to present the check before the bank, before every 15th of the month.
So that only that 5 lakhs has been dishonored.
No, the
One lakh,
first check-
1,50,000.
First check is 5 lakhs.
So my present instruction that they are not paying regularly, Lordship.
No, we are
So
paying regularly.
according, that is the reason when 30 lakhs is used, then you should, the shoppers notice with the warrant of arrest, Lordship. So they
Lordship,
can,
the
they can give clarify reason to the authority, and by this time they can deposit a good amount so that we can do the same thing. So as per my instruction, they are not paying regularly, Lordship. And this is the only documentation and agreement which was made on 09 Annexure 4, that is already cancelled, Lordship. This is my instruction.
What is the amount that they have got to pay? 5 lakhs plus?
Present outstanding is 30 lakhs plus, Lordship.
That is
Yes,
a
yes.
different thing. As
Yes.
per the installment plan,
As in today, they have paid 12 lakhs outstanding.
how much were they supposed to pay as on today?
Yes,
Be-
yes.
Because 5 lakhs have been dishonored.
Yes, yes, yes. They have paid around 12 lakhs. Now, today the balance amount is 30 lakhs 78,316, Lordship.
No, Mr. Council, why don't you understand what I'm trying to say? You see, they are supposed to pay 1.5 lakhs every month
Yes.
from May 2023.
Yes.
So from May 2023 to this month,
Yes.
it will be how many months?
Seven.
May, June, plus 8, 9 months.
Yes.
9 months into 1.5
Yes.
will be how much? It will be 13.5.
30 plus plus.
13.5 lakhs. So if they have paid
12,69.
1269, then where is the question of dishonor of 5 lakhs?
No.
That
5 lakh was not this one, 5 lakh we have paid.
okay.
That has been taken by them also. In terms of the settlement agreement, we have initially paid an amount of rupees 5 lakhs. Then we are regularly paying 1,50,000.
He was saying that something has been dishonored.
Yes, 1 month loss that has been dishonored because
Okay,
they
1 month.
presented the check after 15. And August. loss is
Let him
dishonored.
pay that. You paid within 1 week.
Every month we will pay loss, every month.
As
Till
per-
the amount is exhausted. And you can also pay.
It was the one mistake. You give him a chance.
Not only mistake, as per my instruction, that agreement which was the executed in Annexure 4, that was cancelled by the authority, Lordship.
On what ground?
Because they are not paying properly, Lordship. What they are saying, what a document they have, they cannot give the proper document, how much they have paid, Lordship. 30,000 are till today. out.
Okay, you tell the court next time. We'll give you a date. As to how much they have paid. They have paid according to you 12.69,
Yes,
correct?
Yes, sir.
And prior to May 2023, how much did they pay? How much did you pay prior to May 2023? No amount.
Only in May settlement took place, loss. That amount is fixed.
Then just for one mistake,
Loss, may I kindly
rethink your policy.
But Lordship, this is public money, what my instruction, they have collected the amount from the employees, not depositors. That is the issue. They have collected the amount from the.
But once you have agreed to that
Yes.
installment proposal,
Yes, yes.
the plan, carry on with that. Why should you just cancel it?
Initially, they can pay at least 50% of the outstanding balance, then they continue the agreement, Lordship.
May I submit one document, Lordship? Lordship, we are supposed to get a big amount of rupees, around 20 lakhs. Because they have not issued the NOC to the vendor, Lordship, they have not released the amount. So if we get that amount, Lordship, only because of the NOC, Lordship, they have instructed the bank not to pay. That is why, and that if you receive that amount, Lordship, then we can also pay earlier also, Lordship.
Mr. Council, this annulment
Yes, sir.
of the installment plan.
Yes.
There is no reasons given
Yes, sir.
in your letter.
Yes, no reason.
Then, so from where are you giving reasons that they have not been paying? They have been very irregular in their payment. Lot of problems have been caused. That is not here.
The only issue is here that the first check was dishonored, the agreement was.
First check was this. How can it be dishonored if they have already paid 12 lakhs?
No.
Because that, you see, right now,
Yes, sir.
they're, as per the plan, installment plan, they were supposed to have paid 13.5.
Yes.
According to you, they have paid 12.69. So basically around 1 lakh remains. Arrear 1 lakh. If arrear 1 lakh is there, then there cannot be a dishonor of 5 lakh check. The 2 and 2 cannot be 5. If there was a dishonor of the check bearing 5 lakhs, then his liability as per the installment plan, as on today, would have been around 8.5. I mean, would have been 5.5, I mean, because this amount paid would have been 8.5. Then doesn't tally. You get my point?
Yes.
Then so we set aside. Or what? You obtain instruction?
Let them to at least 50%, Lordship. At least as per my instruction, they are not paying properly regularly, Lordship. And they cannot submit that.
But your letter doesn't say that.
Yes.
The impugned letter doesn't say that.
Yes, the letter is only saying that as the first check was dishonored, so we have.
No, doesn't say here.
Yes.
Doesn't say.
The check number so and so in the second line.
Oh, okay. Mr. Council, you said there is a sum of 43 lakhs is due from you.
30 lakh, the amount is Lordship 30 lakh. The amount due is rupees 30 lakh. 78,361.
No, of this letter of 2021 shows that you've got a liability of 43 lakhs.
No, that amount we have paid now. Now, as on date, Lordship, the amount due is 30 lakh 78,361. That they have also admitted. And till now,
This
Lordship,
30 lakhs is due as on which date?
as on date,
May,
Lordship,
as on today.
Today, Lordship.
Oh, as on today.
As on today, Lordship. And we have paid Lordship 12 lakh 69,959. 5 lakh is not additional. 5 lakh we have paid initially for the settlement agreement on 9.
You please you obtain instructions.
Yes.
And give a list as of May 2023. What they have paid, what checks,
Yes.
and which has been honored, which has been dishonored.
Yes.
Then we'll see.
Lordship, in fact, I have also annexed the bank statements, Lordship, in my report.
Let him be. Right, Mr.
SK Das.
S.K. Das, Learned Counsel for the petitioners, submits that in terms of the installment plan which had been agreed to between the parties, the petitioners were to pay rupees 1,53,993 per month as interest EPF dues in 25 installments. The same was accepted by the respondents where accepted where
Accepted, Lordship, on 17/5, Lordship.
by letter dated
Letter is paid
17/5/2023. No, cannot be. Annulment of order dated 9/5/20. Where is this order 9/5/2023?
9/5, Lordship, at page 19, Lordship, 19.
By 9/5/2023. However, there has been an annulment of the installment plan. And the petitioner has been directed to pay the entire amount of rupees 30,78,361 as EPF interest due. Mr. D-Day, on the other hand, submits that the annulment of the installment plan had been made due to the checks of the petitioner being dishonored by the bank due to insufficiency of funds. Next para. He submits that he will bring the particulars of the checks that were dishonored and still remain dishonored till today, by the next day. Leaves the matter on. When?
After 10 days.
Leaves the matter after 10 days.
Lordship may kindly give me some protection, Lordship.
No, we'll
No
stop it.
protection, Lordship may kindly.
No. There's no question of protection. These are the workers' monies, not yours. Leaves the matter on. Today is 29. Leaves the matter on 7 or 8? 8.
Obliged.
May it please your lordship.
Lordship,
Lordship,
I am very ill. Let me taken up day after tomorrow. I could not go to the case due to influenza.
lordship, it will take 5 minutes. Lordship, may kindly take up my IA for a moment. Only,
Just a minute.
lordship, the IA have been filed by the
Very
government.
hard, my lord.
Only
I'm very hard, my
clarification
lord,
from this
because
honorable
I'm
court
not
for
well.
close the tender.
I have
lordship.
requested my friend.
The writ petition may kindly take up on the 1st of February, lordship. I have no objection, but IA
Only
lordship will be
entire
kindly
matter
taken up.
can be disposed of, my lord. day
Lordship,
after tomorrow.
I can be taken up. It will
Entire,
take 5
because
minutes,
this
my
is
lord.
case voluminous.
No,
I
lordship.
could not go to the case. Let it be taken up. day
Yeah,
after
for
tomorrow.
the writ petitioner.
Yes.
My lord, yes, my lord. I have got the stay order and they were hard on the passing the interim order. They were hard. And now article this 226 clause 3 does not apply. Because this article will apply only an expiry order under the constitution. And that's why I will I will make the submission and judgment of the High Court that under article 226 and 3 can be applied if an order is passed ex parte.
Can be applied.
Apply. If the order is hard, if the case is hard,
There are conflicting decisions, Mr. Counsel, with respect to 2263. There are conflicting decisions of the division benches of this court.
that's I will
So none of you will be right and none of you will be wrong.
I will try to satisfy lordship day after tomorrow because I am not well actually. I have suffered, I have taken the medicine due to just coolness.
Then why did you come? You should have slept
No, just
in the bed.
because my lord, I know that I should come to your lordship and I will request your lordship for only one day. That is what.
Lordship,
She will be satisfied day after tomorrow.
Lordship may kindly take up the matter on 1st of February in a writ petition, but I, Lordship, may I submit, my lord?
Okay, what is-
Lordship, the background of the case is this, Lordship. In the year 2022-23, the Director of Solar Areas has floated a tender for supply of the battery operated spray machine. It is for the purpose is to assist the poor and marginal farmers to help their farming, Lordship. It is the simple tender process, but the director has, due to some reasons, he's emerged to be the second highest bidder. The
Okay.
first one is the another one. The director has cancelled the tender process. We have not allotted to anyone. We have cancelled the tender process, and the cancellation order is before this honorable court challenged by this writ petitioner, and this honorable court had ordered it 12/4/2023. Lordship, it will take only 5 minutes, my lord.
It
Page
will take my
date-
lord an hour
page
to be
date
done
of
because
my
case has to
IA.
be hard.
I
And their
have
case
filed the
because
IA,
if
Lordship.
the IA is allowed,
Lordship.
the decision will be infectious.
Lordship,
Yes,
may I-
Telegram, yes.
my lord.
IA 122/2024, my lord.
Yes, I have got it.
Lordship,
Which
page
page?
10, my lord.
Picture.
Lordship, this is the order passed by this honorable court, 12/4/2023. Then the relevant portion is, my lord, in paragraph 7. Page 11, paragraph 7, the interim order that has been passed by this honorable court.
Paragraph?
Paragraph 7, my lord.
Yes.
May I read, my lord?
in view that it is directed that till the returnable date, no steps should be taken for initiation of any fresh tender process for the items which were the subject matter of the earlier tender process. That the item that this honorable court has not reflected the year. This is the problem for us, Lordship, because this is the tender process for the year 2022-2023. Now we are going to float the tender for 23 to 24. But the items which were referred in this order, my lord, this is the item we have to float.
Is it a recurring tender process every year?
Yes, my lord.
I doubt.
Yes, my lord. I have the budget allocation.
Anyway, since he wants it day after tomorrow, we'll dispose of the entire thing day after tomorrow.
Yes, my lord.
We have the
Tomorrow I will
holiday,
have
my
to
lord.
do-
First,
Oh, yes.
Only
Day after
for one-
tomorrow is the holiday, correct.
Only for one day, tomorrow.
Tomorrow? Okay, you want it tomorrow? We'll do it tomorrow.
Tomorrow, my lord, I will hire, yeah, this, entire case can be dismissed now.
Tomorrow.
If the IA is allowed, it will be infectious.
So you want,
Further, it can be infectious.
so you want it tomorrow?
Tomorrow.
Okay. Tomorrow?
my lord.
Why they are so
My
hurry?
Yes, we have to complete the process
The
by
private
31st of
respondent
March,
does
my
not
lord.
come, and for private respondent, they are taking, my lord, but the steps, I will show you lots of tomorrow.
This is
And I will bring the
wrong
documents.
decision made
I-
by
I- I
my
will-
senior lordship.
My
Because
lord,
I have,
my
I'm
lord,
preparing for the department and we have to float the tender for the
I am
financial year
personally not
2023,
telling- I
2024.
am not personally telling my friend.
The
It
wrong
is the- it is
submission,
the-
but then there
it
is
is
a
the- it
judgment
is
of the
the-
apex court,
it is
he
the-
have to pay cost.
It is the
Because
conspiracy
he
of
is
the
restraining
respondent.
the tendering process.
Anyway,
I have the.
anyway.
Let her, because.
Look,
I am
look,
not
look, look.
personally
Say, for a sick man,
I am
you are very,
Yes,
you have
my
got a,
lord.
you are really trying hard. You should take it easy because you are a sick man.
Lordship, I have to
So-
submit that thing on last occasion. He was so excited and the dispose of the to dismissing my IA, but this honorable court not dismisses my IA and pick this date. Now he is sick.
She should not blame a young girl.
Yes.
Should not blame me like an avid man. Tomorrow, if she wins, I'll be happy.
No, it's okay. Cool down. Everybody, please cool down.
Yes.
We'll have it tomorrow.
My lord.
As agreed by the council for the
My
parties.
lord.
As agreed by the council for the
Yes.
parties, list the matter tomorrow.
Tomorrow.
I'm
Obliged.
deeply obliged, my lord.
Obliged.
Before my learned friend begins, this is a IA file for modification of an order, but in a disposed of petition. So it is akin to a review, your lordship. So perhaps it has to go before the appropriate court.
What is this matter regarding?
It is an IA, it's styled as an IA for modification of an order, but the order is passed in a disposed writ petition. So it is akin to a review, your lordship.
No, it's not a review.
Because,
Where's the question of review?
because the order which he's seeking modification of, it's that is the order by which the petition was disposed of.
What modification is he seeking?
He's if your lordship has the order at page number 81 of the IA. Perhaps if I leave it to your lordship,
Yes.
the order starts at 81. This issue was that there was a dispute between two parties regarding a shop, your lordship. And the direction passed was that we should, upon an application by the alleged person or party which was allegedly in possession of the shop, we should process their electricity connection. That was the direction. And
That has to be done. They have
Yes.
to be given temporary or either
That is the
permanent or
direction.
temporary. Yeah.
So I was only apprehensive that since the matter was disposed of by that order, modifying it by way of an IA, your lordship, whether that is
No. So what did the court say?
the court disposed of the petition, the directions your lordship will find at 84, your lordship.
So he's asking for restoration. So who are you?
I'm for the,
petitioner of this IA, my lord.
And you were the respondent in the writ petition.
My
What
lord,
were you in the writ petition?
the writ petition, my lord, para 4, my lord, I am seriously affected, my lord. Actually, what happened, my lord, I have a shop. The writ petitioner illegally occupied that shop. In that shop, there is a electric connection he concealed and he steal that electricity connection and thrown away. Thereafter, he installed a new electric connection. And thereafter, I complained when the writ petitioner, when I complained, thereafter, my lord, what happened? The electricity authority cancelled his connection.
Electricity authority cancelled his connection.
Cancel his connection. And when I complained, my lord, my lord, kindly see,
Mr. Counsel, the issue is this. First of all, you are not the writ petitioner in
Yes.
okay? You are the respondent.
Yes.
So you are fighting over a shop,
Yes.
it appears.
Yes.
Both of you are fighting over a shop as to who is the owner of the shop, correct?
Yes.
That issue will be decided by the civil court, not by this court. Number one. Is there any pending cases in the civil court between
Yes,
you?
Mr.
There is a pending case.
Yes, yes.
Now, because of your complaint,
Yes.
the electricity was disconnected.
Yes.
Correct?
Yes.
But he cannot be deprived of electricity as per the judgment of the Supreme Court. He has to be given a temporary connection at least.
What happened, my lord? He has no Lucas. In my shop, he illegally occupied, and in that.
Yes. Now, what is your case? It is your shop. It is not his shop. What is your case?
My lord, kindly see.
Where is your senior?
He's out of station.
My lord, kindly see page 106, the order of Deputy Commissioner.
I'm not going into title or who is the owner. I want to know what is your case. You've got no idea. Huh? No idea at all. And you're holding that brief just for the heck of it to show that you're holding a brief. Please read something.
I have get the brief by the morning, sir.
You got this brief today. When is your senior coming?
Day after tomorrow.
Day after tomorrow he's coming. Okay, right. Third, Mr.
M.H. Chaudhary.
M.H. Chaudhary, learned counsel for the petitioner, who submits that the petitioner herein was the respondent number
7, my lord. The respondent number 7 in the writ petition.
was the respondent number 7 in WPC 3561/2023, wherein the petitioner therein, Surab Ali, Surhab Ali, had prayed for restoration of the electricity supply to his shop. First up, this court disposed of WPC. The case in which the petitioner herein was the respondent number 7 was registered as WPC 3561/2023. Next para. WPC 3561/2023 was disposed of by an order dated 21/6/2023. With a direction to with liberty being given to the petitioner therein, Surhab Ali, to apply for fresh connection by following fresh connection for supply of electricity Full stop. Next paragraph. The petitioner, in this case, who was the respondent number 7 in WPC 3561/2023 submits that the petitioner, no, that the respondent number 7 herein, Surhab Ali. Yes, Surhab Ali. Now, Surhab Ali has been illegally occupied the petitioner's shop. And as such, no fresh electricity connection can be given to the respondent number 7 hearing. Is respondent number 7 out here?
Is the respondent number 1?
Here in IA, respondent number 1.
Acha, respondent number 1. Acha, this is a respondent number 1. Huh? Respondent number. Acha, this is not a new writ. This is.
It's the IA for.
So I was slightly confused. Huh. First up. The issue the issue with regard to possession and ownership of the shop BHETI Betty number 195 bracket K at Moira Bari Bi-Weekly Market is pending adjudication in which court?
A title suit in Munship number 1 in.
Title suit number what?
No, my lord, I have the title suit. Title suit 245 of 2021. my lord.
245 of 2021
1.
pending in the court of
Munship number 1, Morigaon.
Munsif number 1 Moregaon. This is between
Sorry, my lord, Munship number 2.
Munsif number 2 Moregaon. So you all are fighting over this property. So that's all. Full stop. Full stop. So actually, please read the entire case again. Order. Please read the entire order. No, submits that the writ petitioner instead of respondent submits that the writ petitioner. Then continue. What else? No. Okay, cut everything. Just I'll give you. Heard Mr. So and so, huh? Heard counsel for the petitioner. Then let counsel for the applicant, let's say. Applicant slash respondent, no, let counsel for the applicant submits that the order dated 21/6/2023 passed in WPC 3561/2023 should be modified. First off, he submits that the writ petitioner and the applicant are having a dispute with regard to title over shop Betty number 195 bracket K at Moira Bari Bi-Weekly Market. While title suit number 245 of 2021 pending before the Munsif 2.
Munship number 2.
Munsif number 2 Moregaon. He submits that as the writ petitioner was in illegal possession over the shop, the applicant made a complaint to the
Deputy Commissioner.
to the respondent authorities, to the state respondent, which resulted in the respondent authorities cutting off the electricity supply being given to the shop. Full stop. However, due to the petitioner, due to the writ petitioner having approached this court by WPC 356/2023, which had been disposed of by order dated 21/6/2023, the writ petitioner's electricity connection is going to be restored, as he has been given liberty to approach the respondent authorities to apply for a fresh electricity connection. The petitions, the applicants, the applicants council submits that the said submits that in view of the above, facts, the order dated 21/6/2023 should be modified. Oh, sorry. Should be modified What is your prayer?
My lord, my prayer page 15, my lord. To cancel the order of the writ petitioner, my lord. And
Cancel the order of the writ petitioner?
my lord, here, my lord. Modify the order dated 21/6/2000 passed by this honorable court in WBC in the interest of justice. We wish to restore the WBC 356/1/2023 to its original file.
Acha, to cancel/modify the order dated 21/6/2023 passed in WPC 3561/2023. Full stop. Next, Mr.
B. Kumar.
KP Pathak appears for the respondent number
3, 4, 5, 6, and 7.
3, 4, 5, 6, and 7, while Mr.
B. Kumar on behalf
B.
of
Kumar appears for respondent number
1.
1. Full stop. Next para. On perusing the application submitted by the petitioner, by the applicant, this court finds that the present case is basically an appeal. It's basically an appeal.
Already
But where's the ground for review? There's no ground.
It is not made out any grounds for review.
It's basically a challenge. It's basically a challenge to the order dated 21/6/2023 passed by this court in WPC 3561/2023 without there being any ground for appeal being made out or or any grounds for review being made out. Full stop. In fact, the petitioner, in fact, the applicant could have approached could have filed a review petition if any grounds for review. Now, if it finds that any ground for review is made out, full stop. The issue of title to the shop, which is in dispute between the applicant and the writ petitioner, is pending before the court of the Munsif number 2, Moregaon. And as such, the said issue will be decided by the said. With regard to whether a temporary or permanent connection should be granted to the writ petitioner, it would be profitable to rely on the judgment of the Supreme Court in Dilip, bracket debt, through LRs versus Satish and others. Criminal appeal number 810 of 2022, wherein the Supreme Court has held that a person cannot be deprived of electricity and that all the electricity supply authorities is to examine whether the applicant for electricity connection is in occupation of the premises in question. In that view of the matter, this court does not find any ground to modify or cancel the order, which in any case it does not have the power to do, keeping in view the facts and circumstances of the case. The application is accordingly dismissed. Okay. There is a Supreme Court judgment, Mr. Counsel. Supposing there is a dispute between regarding ownership of premises. Now, you might have a better case, but till that issue is decided by the trial court, you cannot cut off a person's electricity supply. Temporary connection has to be given, if it's not a permanent one. You cannot make them suffer. Yes.
In this case, I have my instruction to do the petition, my lord, which is prior to
With the friend
the
of what?
party, if
Huh?
necessary. Well, I think the petition can be filed.
Because of your affidavit, I think. Anyway. Para 5, I think, of your affidavit. Anyway, right. On the Mr. M.H. Raja Barbuyan, learned counsel for the petitioner, prays that the matter, that he may be allowed to withdraw the writ petition. With liberty. What liberty?
If necessary, my lord.
Not what, why?
Because there may be another advertisement, my lord, and I am the correct applicant.
That does not bar you.
Yes.
That does not bar you. This is item number
15, man, 1 5.
Para 3. Okay. With liberty to file afresh, Mr.
Yes, yes, I am for the private as per.
Here, madam. Miss
I'm S Kakoti for 1, 2, 4, and 5.
Miss S. Kakoti, appearing for response number 1, 2, 4, and 5. And Miss
Yeah, my name is H O D for 3.
A. Chaudhary for response number 3, submit that they have got no objection to the same. Accordingly, the writ petition dismissed, come with liberty, as withdrawn, with liberty of faith.
Obliged.
All right.
May it please your lordship. Lordship, for not the higher charges and non-matter.
Yes.
Hello. There's some my lord, claim amount and admitted amount. Anyway, my lord,
Let
can
them
dispose of my lord.
pay, my lord, whatever is.
They have already verified, madam. Haven't you read the affidavit?
Yes, yes, I have gone
Then
through it. They
what
have
is that?
admitted. to the
Come to your para 5.
Yes, ma'am.
Yes, my lord,
Then-
59 lakh 67,007.
Then what does remain? Then you have admitted the amount.
No, they are claiming 63
Huh?
lakhs.
63 lakh,
Huh?
They are claiming 63
3 lakh.
and not, but
No, you see, now you are asking for 59 lakhs.
No, my lord, we have asked for 63 lakh 44,736.
But then they have asked for sanction of 59 lakhs.
Yes, my lord. Yes, my
So
lord.
that amount only.
That
We
amount
can-
may be paid, my lord.
You're right. Heard Miss
Yes, Kakoti, my lord.
S. Kakoti, learned counsel for the petitioner. And Mr.
G. Bukulial.
Learned counsel for
All respondents.
all the respondents. The petitioner's counsel submits that the petitioner has not been paid his contractual dues amounting to rupees 6344 736 for the use of his water tanker and bolero by the respondent number 3. So the registration numbers of the 4 vehicles are, it's in the synopsis, sir. The petitions council submits that though amount of rupees 63,44,736 has been submitted to the authorities as higher charges for the vehicles, however, the said amount has not been paid to the petitioner as on date. Full stop. She also submits that the respondent number 3 has in his affidavit in a position dated 12/1/2024 in para 5 admitted to the amount of rupees 59,67,717 for which sanction has been asked for from the authority, from the concerned authority for payment of the hiring charges to the petition. Accordingly submits that a direction may be issued to the respondent authorities to pay the said amount within a specified time period. Next, Mr.
G. Bokolial.
G.
Bokolial.
Bokolia,
Right.
learned counsel for all the respondents, submits that he has got no objection to the prayer made by the petitioner's counsel, keeping in view para 5 of the affidavit dated 12/1/2024 submitted by the respondent number 3. Next, I have heard the learned counsel for the parties. Para 5 of the affidavit in opposition filed by the respondent number 3 is to the following effect. Take it out. I'll put this here. In view of the fact that the state respondents have admitted that they owe the petitioner. No, have admitted to the fact that sanction has been asked for payment of rupees 59,67,717 from the authorities for hiring charges to be paid to the petitioner, it is clear that the admitted amount would have to be paid by the state respondents. Accordingly, the respondents are directed to pay the amount of so and so, 59, so and so, to the petitioner within a period of
3 months.
3 months from the date of receipt of a certified copy of this order. This petition is accordingly disposed of.
That's in item number 18, I'm appearing for the petitioner. In item number 19, I have the instruction to appear for the respondent number 7.
Is it connected?
That's the newly implemented respondent number 5 in item number 18 has filed the item number 19.
So what is the case?
The lawsuit is regarding a extension of a period of a market lawsuit settlement. So that the petitioner was allotted with the market of under Sibsagar Municipal Board lawsuit, central market in ward number 88. So for the year
Central market
lawsuit,
in ward number 18.
ward number 8 lawsuit.
8 for how long?
For the year 2022-23 lawsuit.
22-23. What is the exact date? Any date?
First March 2023 last date. So period is over by 30.
No. From which date?
First of April 2022.
No lawsuit.
But here is just 10 months, yes.
Lawsuit, may I submit lawsuit? 31/5/2022.
31/5/22
22
to
31/3/2023 lawsuit. For a period of 10 months.
He's getting 10 months because of this something.
Okay, so 10 months.
Lawsuit, I have annexed the allotment letter in annex.
So now what is the, so you have asked for extension?
Extension that was
Granted.
That was granted by the municipal board. It was forwarded to the Director Municipal Administration, Lordship. But there is a in between, Lordship.
Who is the authority who can give the extension?
It is required to be the board is required to be adopted resolution, and then the Director Municipal Board is.
So unless the director gives the approval,
Lordship.
it is not an extension.
Yes, Lordship.
It is only a proposal.
Yes, Lordship.
Then
As because the extension of the director was pending, Lordship, the petitioner was allotted to run the market on daily basis by an order which I have annexed at Annex 3, Lordship. Okay. Annex 3 at page 31, Lordship. It was allotted on daily basis at the at rupees 22,253 with effect from 1/4/2023, Lordship.
so you are allowed to collect taxes
On daily basis.
on daily basis.
On daily basis. Not
From when? From when? From when?
From 1/4/2023.
And you're collecting till date.
Till date. Lordship.
So-
So,
And there is no extension given.
no extension.
Then what is the
So,
case?
Lordship, I approached this honorable court as because the resolution passed by the board. Resolution passed by the board is not executed. I was not given the extension.
So
So,
what is your right?
So, Lordship, there is a stated in the provision.
Let us see the provision.
The decision of the board has to be given approval by the government. But government did not give approval, my lord, and that is our.
So I want him to show me,
Yes.
as
No.
is it mandatory for the government to accept the proposal?
No, Lordship, there is a rule. Lordship got the Assam Municipal Act 1956. Lordship, the rules for procedure for sales and pounds and markets of municipal board and town committees in Assam.
224.
Huh?
Case number 224.
224.
So, well, like, you can see that.
Yes, rules for procedure for sale of
Lordship,
pounds and markets.
The
Yes.
rule 2 says the Lordship. Rule
Yes.
2 of that particular rule.
Okay.
The period of lease for a pound or market shall be 1 year, provided the board may, if it thinks, with a previous approval of the director municipal board, extend the period of a lease for a total period of 2 years, but not exceeding 1 year at a time.
Now, you see, all the settlement was done on the basis of advertisement. Where is that advertisement?
Then Lordship, I have not,
There is nothing else.
that was, I think the settlement order, Lordship.
In the advertisement,
Lordship.
does it say for 1 year?
Yes.
Say for 1 year, correct? Now, it doesn't say 2 years,
No,
or says 1 year. So assuming that you were to get for 1 year
Lordship.
and you were given only for 10 months,
Yes, Lordship.
the fact that from April, you are still continuing to today,
Lordship.
that means you have been working for more than 1.5 years already.
No, Lordship, the thing is
What's
that-
your right?
The thing is that the resolution adopted by the board extending my period, that was not executed. It was,
Executed? No,
was
no,
not-
even that was not approved. Not,
Yes, sir.
there's no question of execution.
Let
Let us see the- let us-
Because it is not approved, that's why.
Let us see the rule where it says that it has to be approved.
Also, this is the
Okay.
rule two of that particular.
So,
My lord, I am appearing on behalf of the respondent board. my
no,
lord.
no.
No, I'm just, my
Wait,
lord,
I've got.
uh,
Yes.
so my lord, now my lord, what happened? He is filing a case for extension to be regular. Now he filed a case, my lord, to go for the regular settlement.
Ah,
Yes, tender.
ah.
So now, my lord, what happened as per the board, as per your lordship, clause 3, your lordship kindly see,
Ah,
clause 3,
yes.
clause 3, my lord.
Yes.
That the sale by public auction, the right of every lease, fine, charge, and in respect of any pound or to collect the authority fees on respect of any market shall be held public notice having been given 1 month prior previously, not later than the 14th day of the February in the financial area proceeding to the that which the lease to be taken. So next lease should be taken from 1st of April. So we have to, my lord, for the before 14th February, we have to, you have to go for the first tender.
No, no, that's okay.
So that
No,
is the So
there's
my lord,
nothing.
in both,
No, Lord,
I
that-
think both will be happy, they will join in the matter. I have sent a message to the
That
municipal.
is it, Lord, sir. This is the gray area, Lord, sir.
There's no gray area, sorry.
But immediately.
There's no gray area.
Immediately when my extension was not given, I approached the honorable court.
So what?
But, and in between, I was,
So by, it amounts to denial of your thing.
no, Lord, sir,
He's running on the daily basis, he's running.
You're running.
no, I'm running,
What,
there is no denial
what
on that.
right do you have? The public are suffering.
No,
The
Lord,
government,
there is
the
no denial on
government,
that. What I am
is
submitting.
in public interest that the fresh tender should take.
No, what I am submitting.
But why you not taking a decision?
My lord, actually, that's why, my lord, even yesterday also I sent a mail, my lord, I'm not getting any, no, decision I cannot take, my lord, decision has been approved by we have taken a decision to, my lord, give approve extension.
Okay,
But that has to
who
be
is the
approved
government?
by the government.
Yes, the government, yes.
Even, my lord, government,
It
my
has
lord,
to-
even taken decision, within only 1 month.
Huh?
It will be in the month of March, it will be, my lord, finished. Even in the extension for 1 year, then you will get for, my lord, it will be by 31st March, it will be over. So that's why, my lord, both sides will be happy if, my lord, go for the first tender, my lord.
Lots of in the order dated 2/5/2023.
Yes, why haven't you taken a decision? Let us settle the matter
Lordship, may kindly peruse page 42, Lordship.
of the
Page
repetition.
42, the repetition 695723.
42 of?
Item number 19.
695723, Lordship.
Forty-two. You see, this is a generous circular that is issued. Why don't you take a specific decision with regard to his case? That's all.
Lordship, otherwise also Lordship, his term will be over. So Lordship may direct the first tender, Lordship, both both are.
Mr. Counsel, let us not do your job.
Lordship.
You expect the court to take up the job of the administrator?
No.
You have to go issue tender, you select this person, that's your job. If we do that, then tomorrow or the after tomorrow, you'll say judicial overreach.
That part, Lordship.
Yes, that is one thing. That's one way of looking at it. And you're not doing your job, but you want us to do your job for you. That's not correct, no. You do your job. This circular
Otherwise
is for
also-
everyone.
Otherwise also Lordship, as per rule 2, Lordship, if the period of lease for a.
No, Mr. Counsel, that is all right. We understand all that. You see, we understand as much as you understand. Our level of understanding is maybe little less, that's all.
Yes, part.
Only thing is that you have got to do your part of the job. Take a decision, yes, no, that's all.
Lordship may dispose of in that line also, Lordship.
Now we can dispose of in that line also. But then you should have done your job. Then at least he could have
See,
challenged that.
Otherwise, extension is not a matter of right, Lordship. It's a
Correct.
law-
It is not a matter of right, but then how does it stop you from doing your job? Hai, because they have taken a decision to extend. Now it is your decision to either accept or not accept. It's not it should not be your endeavor to have an ostrich-like attitude, put your head under the ground. I do not see anything. Let the world go by. Not done. Anyway, right. Yes. You're for whom?
I'm for respondent of five. I have already filed a petition challenging the decision taken by the Chipsagar Municipal Court.
Tell me the extension.
That no, my lord.
Where is the extension page?
Already no extension order.
Daily basis, my lord.
They have-
Where is that? Which page?
I have
In my repetition, I have an.
Page.
There's a resolution adopted, Lord, sir.
So my lord, the basic facts of the case is that the Chipsagar Municipal Board
Page number 24.
adopted a resolution, and on the basis of the resolution, they have give the direction to the petitioner that the Honorable Das, he has collected the daily basis from the market. Now, the moot question whether he is, how can he collected the revenue? Because already the director approval is necessary. So Lord, you kindly see.
Correct. Without the director's approval, he could not have collected.
So Lord, you kindly for a Lordship, kindly see page number 35.
35 of the first writ petition.
Petition. That is the only book.
Yes, it's all in Assamese. Sorry, I can't read.
That is the, I say that.
Which page, Mr. Counsel? This is in Assamese. Please read the English version.
They have not
English is there.
appropriately only from the, only green signals from the government side.
Huh?
They have stated that without they have taking any approval from the director, they have only green signal from the government of the concerned of the department. So my lord, so as per the rules too, so it is specifically provided. So my lord, the director approval is necessary. So approval means they have taken a resolution, but it was not ratified.
Okay, we heard.
So my lord,
Heard. Heard, Mr.
Didas.
Huh?
Didas.
Didas, learned counsel for the petitioner in WPC 6957
No,
slash.
2258.
Huh?
2258. Item number 18, I am the.
Oh, sorry. 2258 of 2023. Also heard Mr.
yes, sir.
S. Sharma, learned counsel for the respondent number 5.
Lordship, I am interpreting, just I have handed over one document, Lordship. It was received from the municipal, but it is there also.
What?
It is.
Director's decision.
Rejection part is there.
There is a rejection.
Rejection part.
Rejection part is there, my lord, and that's why, my lord, we have no, my lord,
Rejection part is
power.
But it is not communicated to me, Lords.
It was granted to him.
That was
Now,
not
my lord,
communicated.
today,
Well, it's communicated now, so you tell your client to stop collecting taxes. Today you can collect, from tomorrow, no more tandoori chicken. Now you've got to, now, eat a little.
decision to, my lord, give him on daily basis, my to him, my lord, because we have no manpower. That's why I granted. No, now, my lord, today regarding, my lord, fresh tender, my lord, we have to be before.
Yes, you do that, you do that.
There is a meeting today, my lord, probably there will be doing.
You do it.
Your lordship, my lord, go for that as per law.
Yes, yes.
And I'll do it.
You carry on.
This is there also.
Can I? Okay.
This is, just let me see.
It's reflected in the order, my lord, the extension order.
It's directly the municipal board, Lordship, Shikshaka municipal board. Lordship.
No, this is by the joint director, again, not by the.
Yes,
The rule says,
Joint director to the municipal board, Lordship. Joint director to the municipal board.
with
Lordship.
a previous approval of director of
Director.
municipal. And what does this, department letter dated 23/6/19, what is this?
Probably, yeah.
23/6/19. Just give it to them, what is this, 1926? Okay, right, heard, Mr.
Yes, sir.
S. Sharma appearing for the respondent number 5 in WPC number 2258/2023 and the writ petitioner in WPC number 6957 of 2023. So Mr. K. Gogoi appears for
Lordship, I am for official respondent. Respondent 1, 2, 3, 5 and 6, Lordship.
appears for the state respondent. That's all. Acha, appear for the state government respondent. While Mr. T.J. Mahanta, learned senior counsel, appears for the.
Item number 18, my lord, I am.
No, we'll just say the board, I think. Will appears for the Shivsagar Municipal Board. Okay, right. The petitioner. Now, the two writ petitions are being disposed of by this common order. In as much as the issue in both the cases are similar and pertain to whether the petitioner should continue to collect tax on a daily basis from the central market at ward number 8, Shivsagar, under Shivsagar Municipal Board. That's right. The petitioner. No, that's right. The petitioner and others have taken part in the selection process for settlement of the central market of Ward number 8 of Sivsagar Municipal Board on the basis of an advertisement dated
Lordship, I have annexed the settlement order
on the basis of an advertisement uh, for the period 2022-23.
23.
Lordship. However, no, the petitioner in WPC 2258/2023 was selected as the successful tender who was to look after the central market. However, due to certain delays and problems, the central market was settled with the petitioner in WPC 2258 of 2023 for a period of 10 months only. That is 31/5/2022. No, it'll be 1/6/2022. 1/6/2022.
But the order was of 31.
Maybe
Plus.
to 31/3/2023.
Plus.
It may be stated here that there is no challenge to the settlement of the market to the petitioner in WPC 2258/2023 for the period from 1/6/2022 to 31/3/2023. Now, why I'm saying this, there is no challenge by you, there is no challenge by him also. So he cannot say that he has not been given a 1 year. So, they have not challenged it. Next. Subsequent to the termination of the settlement period, expiry of the settlement period of the market with the petitioner in WPC 2258/2023, where is that extension?
Extension order, Lordship. Page number 24, the relevant portion.
Your petition.
In my reports, 2258.
The
Page number 24, down below COP. This paragraph.
the Sibsagar Municipal Board
Lordship.
approved the proposal for extension of the settlement of the central market to the petitioner on a daily basis.
No, Lordship.
No,
So,
for the period,
Full term.
for a period of 1 year,
Lordship.
from 1/4/2023 to
31/3/2022.
31/3/24.
Lordship.
Right, resolution dated
Resolution dated 13/3/23. Lordship.
13/3/23. Full stop. The said resolution was, however, to be approved. The said resolution/proposal was, however, to be approved by the Director of Municipal Administration. Full stop. The petitioner's counsel submits that though the petitioner has been collecting the taxes from the central market on a daily basis since 1/4/2023.
In terms of the order dated 31/3/2020. So Annex 3.
Page
31. Lordship.
in terms of the page 20,
Page 31. Lordship. 31 Annex 3.
in terms of the resolution passed by the Sivsagar Municipal Board on
31.
no, not 31, it's 31 or 13.
31/3. Lordship, the Annex 3. the daily basis for collection of daily basis.
Acha, on 31/3. Huh?
Page 30.
You have not translated this document.
Translated also. I have,
Where is
page-
the translated?
Page 31 also. Read petition number 2258.
Where do you get the magic date of 31/3?
Lordship, the page 33, page 33 down below. Page 33.
That says 13/3. Does not say 31.
Lordship, page 33, it says 31/3. Lordship, page 33.
In a vernacular, it's 31.
33 also 31 also. In our-
Huh?
No, 31/3. Lordship. The resolution was of 13/3.
Acha, wait, sorry. There are two files. No, I was doing the wrong file. No, I was on the wrong file. Okay. 31/3.
31.
2020. Full stop. Next, the petitioner in WPC 2258/2023. Praise that. Direction should be issued to the Sifsagar Municipal Board to issue a formal order extending the period of settlement of the central market of Ward number 8 in favor of the petitioner in terms of the resolution number 1 bracket KA adopted by the special meeting of the board on 4/3/2023. 4/3/2023.
Or the meeting was on 4/20.
4/3/2023. Hey. Full stop. Full stop. Next file. The councils for the respondent, councils for all the other respondents submit that the proposal to extend the settlement of the market with the petitioner made by the Sibsagar Municipal Board needed the prior approval of the Director of Municipal Administration in terms of Rule 2 of the Rules for Procedure Town Committee. Rule 2 or what is this? In terms of, in terms of Rule 2 of the Rules for Procedure for the sale of pounds and markets by the municipal boards and town committees in Assam, as notified by notification number LML 51/58 dated 24/6/1958. I put this marker here. They submit that unless the previous approval of the Director of Municipal Administration is given to the proposal for extension of the market in favor of the petitioner in WPC number 2258 of 2023. The proposal the proposal made by the Sibsagar Municipal Board has no validity and cannot be acted upon. Full stop. Next para. Mr. T.J. Manta, the learned counsel for the Sibsagar Municipal Board, also states that in terms of Rule 3 of the rules for the evening, that the right to collect taxes and levy fines in respect of marketplaces would have to be initiated by the municipal board before 14 February of each year. And as the proposal by the municipal board for extension of the settlement of the market in favor of the petitioner in WPC 2258 of 2023 has not been approved by the Director of Municipal Administration, the petitioner does not have any right to carry on as the settlement holder of the market. Next. I have heard the alert process for the parties. Rule 2 and 3 of the rules and regulations states as follows. Huh?
But that's why we are given in daily basis.
First-
That is
Acha, then you write one thing just before that. Mr. T.J. Manta submit that as in view of the above facts and circumstances, the petitioner in WPC 2258 of 2023 had been allowed to collect tax from the market on a daily basis.
In terms of the order dated 31/3/2000.
In terms of the order dated, in terms of the resolution passed by the municipal board on 31/3/2022. I have heard another cause for the parties. Rule 2 and 3 of the rules also states as follows. A perusal of the above rules clearly goes to show that the extension of a settlement holder of a market can only be made with the approval of the Director of Municipal Administration. And no right accrues to a settlement holder whose proposal for extension has not been acted upon by the Director of Municipal Administration. Next paragraph. The Rule 3 also provides that the settlement of markets should be initiated prior to 14 February of each year. And in view of the above facts, it would not be, there is no ground to allow the prayer of the petitioner for extending his settlement rights over the marketplace, over the central market, which had expired on 31/3/2023. Consequently, in view of the above reasons, the WPC 2258 of 2023 would have to be dismissed.
Then the matter may be referred to the director, Lordship. The director has not taken any decision. Lordship, in this count, there is a judgment of a division bench also, Lordship.
Says what?
Says Lordship, the proposal is to be sent from the municipal board to the director. And it is required to be accepted. It is a
Required to be accepted.
Lordship, the director is required to act upon the.
It can be acted.
This is a.
What have I said? Would have to be dismissed because your prayer is not for to be decided by the director. Your prayer is for a direction to regularize the settlement.
Regular settlement
First
unless.
off, consequently, the director is accordingly directed to take a decision on the proposal made by the Sibsagar Municipal Corporation with regard to extension of the petitioner's settlement of the central market of Ward number 8 within a period of 1 week. With a period of 1 week from the date of receipt of a copy of this order. Full stop. In the event no decision is taken by the director, the Sibsagar Municipal Board are given the liberty to initiate the process for a fresh settlement of the market in terms of Rule 3 of the rules.
Till then, the petitioner will continue as a daily collector.
The question of the petitioner continuing as the collector of taxes on a daily basis is however left to the discretion of the authorities. Keeping in mind the fact that a fresh selection would have to be carried out for the period from 1/4/2024.
Lordship, the status quo may be directed to be maintained. Lordship, he is continuing. There is no prejudice.
No. The writ petitions are accordingly disposed of. Naturally, both the petitions.
That's
Yeah, clear, Lord. My lord, this is an,
Your Honor, I would like to ask that you would humbly allow this matter to be passed over for this moment because my senior is still engaged in court number 17.
Okay, but for the moment,
Thank you.
We should file affidavit, but we did not file affidavit.
anyway, we'll see if we can dispose of. Item?
23 men.
Lordship, my senior is on legs. Can it be possible for the time being?
Even my senior will have some difficulty today. May I
You
pray?
see, what is this, what is this issue?
Well, here that my contract has been cancelled. I was running a parcel van from Guwahati to Delhi and back. So what happened is there is a policy.
Parcel?
Parcel van, railway parcel van. So there's a policy for me to ask for change of unloading station. That was allowed in one location, one particular station in Delhi, however denied in one particular location in West Bengal. So over that issue, finally they cancelled my contract. So I have come against the termination.
Is there any arbitration clause?
There is an arbitration clause and I have judgment to show why arbitration, we may not go for arbitration and we may agitate the issue before it's allowed.
No, you have judgment to show that you may agitate. But is there any bar for this court to direct you to go to arbitrate, to the arbitrator?
Yes,
I have
there are,
Huh?
there are, arbitration, they can avail that arbitration.
That's what I'm thinking. If there's an arbitration clause, why should we take it up? These are basically discretionary powers, I think. There's no right that you should send your parcels or through a particular station. That is, I think, unless it is written in the agreement that it will be done from a particular station.
And once, it is
Provided, these
Huh?
things are provided, my lord, even
Show
in
me,
the policy.
show me.
My lord, what I'm saying, there is, my lord, my senior has some difficulty.
We'll wait for your senior. We'll wait for your senior.
Well, perhaps in the second.
We'll wait for your senior.
second amendment.
Whatever.
No, bless. Ready for.
May I please, your lordship, settlement of a market, your lordship. Settlement is for 1 year. And already, my lord, 6 months have already been passed by filing of this writ.
Let us see the settlement order.
Yes, sir. My lord, page 25, my lord, is the settlement order. Correct. Page 25, my lord. With reference to the subjects, I am informed and allowed to go ahead with the collection of toll fees from Balibra weekly market.
So where is the formal settlement order?
My lord, no formal settlement order issued, my lord. And on the basis of this document, my lord, they are continuing private respondents, my lord. We have taken.
But
steps.
this is more than, I mean, now, we don't know till which date this will continue.
Yeah.
This settlement of the market,
Yes.
it does not give a date, does not give a period.
Yes, well.
Then?
With effect from 1st July,
Maybe first July till when? Till kingdom come or what?
that, my lord, they are continuing that case. The advocate for the other side is here, my lord.
Where is it?
Few minutes back, I have seen her.
Huh?
Time being, then I'll call her.
Okay. Next, for the time being. Time being.
25.
This is also a matter regarding settlement of a market. But the rules itself provides that a market settlement period starts from 1st of July to 30th of June. That is 1 year. So the Panchayat rule itself postulates that, you know. Now regarding my case, again, the same situation, we're running out of time. What has happened in this matter is a tender process was out. Pursuant to that, there is a government value. And against that, the bidders are supposed to quote their value, which is above the government rate. Now, in this particular NIT, people have quoted, the comparative statement was prepared. Then finally, it was seen that there was a cartel been formed because the government value per month was around 69 and 69,000 per month. And the rate that was quoted by the highest bidder therein was around 71. So around just 2,000 rupees difference. Whereas in the last year settlement, the amount went to 1,50,000 or 70. I'm just placing that. So it was a huge gap.
So therefore, what the authorities have done, conscious decision was taken that they are going to cancel this process and they are going to re-tender it. Pursuant to that, a re-tender notice was also issued. Dates were given. The re-tender notices were there, tender papers were out. We had gone there and we had obtained those tender papers. On the day when we went to submit our bids pursuant to the re-tender process, we were informed that no, the authorities have now, in a very clandestine manner, settled the market with a bidder pursuant to that first NIT process, which in my humble submission has been cancelled. And pursuant to a cancellation only, they had gone ahead with the new NIT tender. So without cancelling this new NIT and without having reasons good enough to again fall back to the earlier process, they could not have, without even giving notice to us.
When was that?
That's it.
When was the settlement was done? Or when? When was the settlement done?
Yes. Settlement has been done at page 78 on 27/6/2023. Page 78. But I need to just place the facts, otherwise then also
Yeah.
clear. Because just reading this order maybe.
No, first of all,
Yes, sir.
just show me the first NIT. Which
Yes,
page is it?
yes. And I think the records are also here, can be taken up for disposal.
Anyway, just
Yes,
show
Lordship.
me.
Yes, Lordship. Page 23, if your Lordship will come, the first NIT. Page 23. Just got that, page 23.
First notice dated.
2/5/2023.
When is the cancellation?
And thereafter, Lordship will now come to page 48. Page 48 is the second NIT, and the clarification is at page 81 under the RTI reply. Page 48 for a moment. 23/6/2023.
This is notice dated 23.
23/6/2023. The concerned market is Boralimari Biocli market.
No, where does it say that the earlier NIT has been cancelled?
That your Lordship will find at page 81 under an RTI reply. They have categorically stated that.
Page 81.
Page 81. Yes, Lordship. I would like to inform that as per the decision of the General Standing Committee, written such and such, the concerned executive officer was informed to take necessary measures to invite short tenders for giving settlement of early market as per suggestions put forward by the members of the General Standing Committee and personal decisions taken by the General Standing Committee. The said settlement notice was cancelled and proposed to give the settlement of the market. So it gives the entire narration of what has happened.
No, but then these dates are not matching.
No, it is lost. What has happened is here in this RTI reply, they have given the narration of the entire facts regarding the first cancellation.
No, are they, you see,
Yes.
the General Standing Committee in its meeting dated 27/6/2023.
Yes.
So now this date,
Before that,
the short tender notice was cancelled. So as per the suggestions in the General Committee meeting, or in the decision taken by the General Standing Committee, if the Standing Committee took a decision on 27 June,
yes,
the notice could not have been issued prior to 27 June.
27/6 is what they are referring to after the short tender notice was issued. Possibly see the date prior to that in that particular letter. 23/6/2023.
Yeah.
On 23/6/2023, they decided to go for inviting fresh short tender notices, which your Lordship will find at page 48. The date tallies 23/6/2023. Page 48.
No, but then, you see, unless
Yes.
General Standing
So
Committee.
they are going ahead and saying what they have done later on.
Okay. Now, what about this 2/5? They do not mention 2/5/23.
No, 2/5/23, Lordship will find the reference in this particular RTI reply itself. On 23/6, they say they're going ahead with this invite short tender notice. That itself indicates that they have abandoned the first process and they have gone ahead
to to initiate a fresh tender notice. Their actions itself says they had cancelled the earlier process and gone ahead to issue a short tender notice wherein that particular concerned market is there. And if you will also see at page 64, they issued fresh tender notices of fresh receipts also. Page 64. That is not a dispute, Lordship, that they had cancelled the earlier tender process and gone ahead with a short tender notice. But prior to conclusion of that process, they suddenly, from the back door, gave settlement to a bidder based on that first settlement process, which they had otherwise cancelled. These facts, I do not believe that there will be a dispute because this is on record. My entire case, if your Lordship will therefore
So
say
that notice of 2523 has been cancelled according to you.
yes, and therefore the short tender notice.
Where does it specifically say that it's cancelled?
Yes, Lordship will see the order itself. I mean, that's page 48 itself. Page 48. The short tender notice.
Yes.
Page 48.
Yes.
This is for the information of all public in general that short quotations are hereby invited to give settlement to the below named market under Lahorighat Anchalik Panchayat for 1 year from the period such and such. Based on the instructions dated, there are two dates, 23/6/2023 and the decision of the General Standing Committee Morigaon, dated 23 this. Seal quotations are accepted. So if your Lordship will just peruse this 23/6/2023 decisions, one of the settlement of the market, the instructions, and number two is the General Standing Committee decisions, it will be clear. My case
And
is,
did you participate in the earlier tender process?
yes.
And you were L23 of us.
I was not in that.
You were not there. You did not participate.
No, I participated. I'll just check. That is a question that skipped my mind. I'll just check, Lordship. Yes, I participated. Number 3.
Number
Petition
3.
number 1 is number 3. Yes.
And you participated in the second one also?
Yes, I participated.
You gave your bid.
Yes, I gave my bids. Bids are also included.
So this selection of the successful bidder was made after the last date in the second tender notice or before the last date?
Before the last date. 1 day prior to the last date. The last date of settlement was on 28. I mean, for the submission of bids 28. And on 27, this order was passed. But without giving any general public notice to anyone, this was done.
Yes. Let us see the standing committee decision.
And the other issue would be the rates. This time the rates that we had bidded for
No,
was beyond.
that's a different issue. That
Yes,
will come. Let us talk one bridge at a time.
Yes, Lord. But having cancelled that process,
Would they
could
have
not
said?
23/6.
I have received this instruction, my lord.
This is a parawise. Where is the
Yes,
record?
reply is, record is not there, my lord.
Huh?
Only instructions and
On the record, sir.
parawise instructions and my lord. The reply to para number 6, this is the facts, my lord. Reply to, may I read, my lord?
Yeah.
In view of previous year bid value of 2,69,000 per month submitted by Sri Kartik Sarkar, lessee of previous year so and so, and view of collection of government revenue. The General Standing Committee of Zilla Parishad Morigaon is its meeting held on 23/6/23 has decided to reissue a short tender notice in respect of Boralimari bi-weekly market along with 3 other markets in the district. As a result, the Chief Executive Officer, Zilla Parishad Morigaon, had issued a letter to so and so dated 23/6/23 to issue a short tender notice in respect of Boralimari bi-weekly market along with one another market. Subsequently, the Executive Officer, Lahorighat Anchalik Panchayat, had issued a short tender notice on 23/6/2023. In the meantime, an application dated 26/6/2023 had submitted by 9 numbers of tenderers, namely so and so, so and so, so and so, mentioning in that comparative statement respectively in presence of some other tenderers, stating that in previous year, Sri Kartik Sarkar, the lessee of previous year, had lost a huge amount for paying the kist money. An application had also submitted by.
No,
Sri
you
Kartik-
see, the issue is basically this. There are two notices, correct?
Right.
Two NIT. Now, the first NIT is of 2nd May 23. Was this NIT cancelled?
Yes. NIT was cancelled, man.
Cancelled.
Mine.
Now, if it was cancelled, a fresh NIT was issued. 23/6/23.
Right.
Now, the selection of the successful bidder has been made on the basis of which NIT?
First NIT, but.
How? It was cancelled.
Yes. Yes, but that was decided by the General Standing Committee of Zilla President.
Correct, but it was cancelled, correct?
I know.
That's the end of the matter. How do you suddenly revive a dead horse?
This is on facts, my lord. And as on law, my lord, Lordship may kindly have the some Panchayat Act, my lord. Section 105 is the settlement of Hats by Ansalik Panchayat.
105. Section 105.
Yes, ma'am. Okay. Settlement of Hats by Ansalik Panchayat.
Yes.
Yes. All huts within the territorial jurisdiction of Ansalik Panchayat shall be settled in the manner prescribed for a period coinciding with and at not exceeding one Panchayat financial year by inviting tenders at the office of the Ansalik Panchayat by its president. So the jurisdiction is with the Ansalik Panchayat. Now, number 2. Detailed procedure for inviting and submission of such tenders shall be such as may be prescribed. Number 3, this is important, my lord. The powers of examination and final acceptance of such tenders shall be vested in the standing committee referred to the section 52(1)(a). Section 52(1)(a) is the general standing committee of the Anchalik Panchayat, my lord, not for the Zilla Parishad, my lord. So power is with the general.
No, you can accept. That is not the issue.
My lord.
The issue is once you have cancelled an NIT,
my lord,
and then you issued a subsequent NIT.
That is there. I have to admit that.
Then how can you go back and select
But otherwise,
a person on the basis of a dead NIT?
My lord.
Cancelled NIT. No, where's the validity?
And this.
Yes, you are paying for whom?
It's whatever started by.
Yes. So you agree? That
No, so far as the initial NIT is concerned, when I standing as highest valid bill.
I'm not on that. I'm not on that.
So far as the minor.
My question to you is, the first NIT has been cancelled?
Yes, as far as records are cancelled now.
That second NIT has not been cancelled?
No, second, no, minor, as part of minor.
No, just please answer the question.
Yes, that is not cancelled.
That's not cancelled. First NIT cancelled, second NIT not cancelled. You are appointed on the basis of your bid given in the first NIT.
First NIT, man.
End of the matter.
No, so some of the standing committee decision taken by the general standing committee of Zilla Parishad.
Huh?
They also find page 81.
Page 81.
Of writ petition. This is the reason why the my lord is a writ petition.
Page 81.
Yes.
That RTI reply that I have
RTI
referred
reply.
to.
Yes. Yes.
Yes, this is my lord, this is the standing committee of Zilla Parishad, my lord. They, my lord, took a resolution. Okay.
Do they have unfettered powers?
Yes, it is a modern law. CRB Assembly is modern law. It is a general.
You see, what they can do is either they complete the second NIT, or they issue a fresh NIT. You have cancelled it, Mr. Counsel. It's gone. It's dead. Show me the power under these rules where you can revive a cancelled NIT.
No, there is any such thing.
Then
Since the my lord.
to exercise power, there has to be a source of power.
Yes, sir.
Where is the power to cancel?
The second short notice was also stopped by the order dated 26.
Okay, so on the basis of two dead NITs, you have been selected.
Then let them
Well,
get third NIT now.
Then
That's
file a
it.
third, make a third NIT, dispose it of.
Everyone should be given a fair chance to participate.
Yeah, let the
I'll be agreeable with that.
until then, my lord, the present, present is maybe.
He,
Huh?
let the panchayat run then. He is enjoying it at 70,000 per month. Whereas on the last year, it was 2,69,000 was the settlement.
It is what.
Therefore, a cartel was formed and
You,
therefore it was
you
cancelled.
complete the selection process within how much period?
My lord, 45 days period is required, my lord, for notice, my lord.
For
For
short
notice.
notice, it will not come in. This 45 days that he is taking this plea, that is for the
No, it's
initiation.
law, it's
Now the
very
period has
law,
already
it's not
started.
my-
In fact, 6 months is gone.
Huh?
It's by law, my lord.
Show me the law.
It's 45 days.
45 days is there.
45 days is there, but for press NITs. Already the period is now going ahead. So that means they will enjoy it till 45 days. That is the ploy. So let it be then run by the Jilla Panchayat. I have no qualms about that.
My lord.
Well, see, I mean, standing, but so far as the my learned
Based
friend
on a
saying
dead NIT, he has got
that
no
in the
powers.
previous year, somebody run the market at the cost of rupees
2,69,000 was the earlier settlement.
It is
This
not-
time he is enjoying
in
at
the-
70,000.
In the present moment, it is quite impossible to collect more than
This is
1
not
lakh.
for him to.
And now 70,000 per month. That means my
That,
really,
that will always be the submission or argument of a businessman. I am not making any money, sorry.
no, the present
time,
is,
you know.
my learned friend, he's appearing in this settlement measures, he knows very well.
No, when
What is
I'll
the
be there on the
present?
other side, I'll argue that.
The,
not today.
the problem is both of you know very well. It's me who is trying to catch up and trying to
What is
find
the
out
present market
who
position?
is correct and who is wrong.
Just because this cartel was formed, therefore it
No,
was
no, that is
cancelled.
not the issue now. Yes,
but-
I
but
want that 45
Price
days.
is a very important factor here in a settlement of a market. Because 4710 says it has to be settled with the highest bidder. All the price has been always given and there are many judgments of the honorable court wherein we always come up
But
with
then
a plea.
there's another aspect to it. Supposing a person gives a very high price.
Yes.
He's going to collect very high taxes.
Yes. There are high court judgments
Ah.
which says that ceiling cannot be applied to panchayat markets. Why? Because there is already a rate chart based on which the tenderer has to collect those
Okay.
rates. There are judgments on the honorable.
Okay, they already reached out.
Yes, we have always come up with the plea earlier. These rates are very exorbitant. How can the government settle with these exorbitant rates? There are judgments of the honorable court which says it will not apply. There is no ceiling. There is no upper level ceiling. And how the bidders are being.
But then
bound to this, there's a rate chart.
they'll have to conform to those rates given in the rate chart.
Exactly. They cannot go beyond. that.
Otherwise, they'll be exploiting the poor people.
Exactly. These grounds we have already taken in earlier matters.
Okay.
This is how it was being dealt with. It's ultimately at the peril of the bidder or the
Yes,
settlement holder.
Mr. Counsel, we are still looking for some things that should be on your fingertips.
Actually, it's amended, my lord, now. The act has been amended. So
Amended
it will
when?
be-
Amended when?
Recently, my lord, last year.
Last year.
My lord. So that
And-
is why in my earlier book that was marked 105
Okay, you
is
do
the.
it, you do it within 45 days.
My lord, my
Until then, let the panchayat be run by the.
wide publication, my lord. 45
It is not that I'm lowest bid, depriving the highest bid, market settle my favor.
No, you have got no right.
Based on a debt.
You've got
debt
no
penalty,
right.
How can you do so?
How can you know, there's nothing legal about or valid about the way you
How
have
can
been
you continue
selected.
even a single day?
Completely illegal.
Let the panchayat run the
Right,
market. I
heard,
have no
Mr.
difficulties with that.
Third, Mr.
Yes, sir, my lord.
A. Sharma, learned counsel for the petitioner. Also heard Mr.
As Dr. for 1236.
S. Datta for 1236 and Mr.
FKR Ahmed.
For
Response number 7.
point number 7.
So, 125 bid.
Yeah, right. You take this order dated 9/10/23. This para 2. Okay. Para 2, 2.1, 2.3, 2.4. No, 2.4. Till 2.4. Okay. Next. The counsels for the respondents both submit that there is no dispute with regard to the facts in question, in as much as, the earlier tender notice dated 2/5/23 was cancelled, and in lieu of the same, the subsequent notice dated, subsequent tender notice dated 23/6/2023 was published. It is also not in dispute. They have also not disputed the fact that prior to the last date of submission of bids in terms of the subsequent tender notice dated 23/6/23, that is on 28/6/23, the state respondents had selected the respondent number seven as the successful candidate for settlement of the market. Settlement of the market. Settlement of the market. In terms of the earlier cancelled tender notice dated 2/5/23. The respondents council also submit that as on date, the respondent number 7 is collecting taxes on the market on the basis of the bid amount submitted by him, that is rupees 70,000 per month. Pursuant to the earlier tender notice dated 2/5/23. Next, I have heard the learned counsels for the party. The facts of the case make it clear that the respondent number 7 has been selected on the basis of his bid amount given in the cancelled tender notice dated 2/5/2023, after the second tender notice dated 23/6/2023 had been issued, the selection of the selection of the respondent number 7 as settlement the settlement of the market with the respondent number 7 is illegal and not sustainable in law. No power has been, the state respondents have also not given any explanation for settling the market with the respondent number 7 on the basis of a cancelled tender notice. As such, as no power can be exercised, in the absence of the source of power, for settling a tender on the basis of a cancelled tender notice, the settlement of the market with the respondent number 7 is hereby set aside. Though there is no cancellation of the subsequent tender notice dated 23/6/2023, this court is of the view that the said tender notice should not be acted upon, keeping in view the fact that more than 7 months have elapsed, and as such, there is a possibility of the change in rates of the market goods. Consequently, the state respondents are directed to initiate a fresh tender process and selection of the settlement holder of the market immediately. Full stop. The same should be completed within a period of.
I have something to say this part, on this part. What he was referring to is the Panchayat Financial Rules 2002. Particular clause is 47(2). Now 47(2) reads as, such tender notice shall be floated at least 45 days before the last day of the Panchayat financial year. So the catch here is 45 days before, at least 45 days before the last day of the Panchayat year. So 45 days is not independent. 45 days is for initiation of a fresh tender notice. And when? Before the last day of the Panchayat financial year. The Panchayat financial year, the definition is the first day of July. It starts at the first day of July. So it is only in matters.
Now what to do?
Lordship has seen a short tender notice.
So we'll have to give for the remaining months.
Lordship will have to see in the short tender notice how much period of time was given for settlement. They have not gone ahead by the 45 days rule because it's always for the first day of settlement. The first
Okay,
settlement.
no,
So
that is one aspect.
So not 45 days, maybe 2 weeks, maybe 3 weeks.
No, only one thing is,
Yes.
now this period for settling the market will be for how long? Will be
38th
till
June.
30th June only.
Yes, Lordship.
Okay.
So there is no time, 30th June.
So we'll,
I will enjoy.
so let it be completed by February. February.
Let them take 4 weeks.
February is 4 weeks.
Yes, but Lordship will clarify that. Otherwise,
Yes.
Lordship, now at present, my lord, only 2 bidders are present here, my lord. Other bidders for wide publicity, at least some days are required.
therefore I'm saying 28 days.
So
one month,
there's
not
enough days.
45 days.
So
That's what
by
I'm saying.
you completed by 29th of February.
Yes, Lordship. Yes, Lord.
Okay, 29th of February. Today is
29.
29th.
Yes, so 1 month. They're getting 1 month.
Okay. So I said what? Within a period of 1 month from today, that is on or before 29 to 2024.
Of life.
For the settlement of the market for the period from 1/3/2024 to 30/06/2024.
Yes, ma'am.
With regard to the running of the marketplace, concerned marketplace, this point is also view that the point number 7 cannot be allowed to continue to run the market on a daily basis, in as much as his very selection and settlement of the markets by the state respondent authorities had been done by blatantly abusing the process of law. As he was selected on the basis of a dead and cancelled tender notice. The writ petitions accordingly. The Anchalik Panchayat shall accordingly run the market.
It will be Jila Parishad, right?
The
Anchalik Panchayat. No.
The Anchalik
Section
Panchayat.
105, section 1055 shall be entrusted in the direct management of the such hut by the Anchalik Panchayat.
1055.
The Anchalik Panchayat shall in accordance with
In accordance with section 105, subsection 5
105 section 5
of
of
the Assam Panchayat Act 1994.
and
Yeah, the yearly sale value is more than lakh. How the Anchalik Parishad run the market?
shall
Yearly,
155 is
Not
the
on
number.
shall run the marketplace.
The Anchalik
Till,
Panchayat.
huh?
The Anchalik Panchayat will run the.
Yes, shall run the marketplace till selection of the successful bidder. In terms of the tender notice to be issued by the state respondents.
My instruction may be kept as record.
The parawise comments submitted by Mr. S. Datta through forwarding letter dated 22/11/23 issued by the CEO Zila Parishad Moregaon is made a part of the record and marked as Annexure X. The writ petition is accordingly disposed of.
Deeply obliged, Your Lordship.
Okay, very well.
Item 20, Lordship.
Because I am supposed to file the affidavit, Lordship. My lord, they are taking time since September, my lord, for affidavit, in the name of affidavit. And an incomplete tender, thereby accepting that incomplete tender, they are doing that, my lord. Because
The tender was totally incomplete. It is a the fact is there, Lordship, on the day of tender, Lordship. On the day of tender, they have given, we will give the affidavit, Lordship. The affidavit will be clear. There is nothing.
Let me hear him first.
Yes,
Yes.
my lord, here what happened, a tender was floated. And there was certain terms and conditions in the tender, my lord. And that terms and condition, my lord, will read it, page 45. Before that, 43 is there, 6-1.
Page?
Page 43. Clause 6-1.
Clause 6-1, yes.
The tender form should be filled up completely as per the rules and norms specified by the corporation and submit with all necessary particulars and certificates. Incomplete tender will not be entertained. It is that terms and condition. Then, my lord, along with the tender, various documents were required to be submitted. That is at page 45. And
Yes, so?
amongst that document, one tax clearance certificate was to be submitted. And that was not submitted, admittedly. By affidavit, they have admitted it. That Bakijai clearance certificate was not submitted. Then, my lord, the consequence will be at page 47. If the bidder is an individual, Bakijai clearance certificate in the name of the bidder should be submitted with the tender. But if the bidder is a cooperative society, Bakijai clearance certificate in the name of the cooperative society as well as in the name of the society who submits the tender for the society.
Which page are you reading, Mr. Council?
I am page 47.
Yes, where? Page 47, where?
Clause 14.5.
Yes.
I am again reading, if the bidder is an individual, the Bakijai clearance certificate in the name of the bidder should be submitted with the tender. But if the bidder is a cooperative society, Bakijai clearance certificate.
Okay, so this was not submitted.
They had not submitted. Now, here, again that I am reading 49 page, clause 20.7. In event of violation of any of these clauses by the lessee, the corporation will have the right to cancel the settlement. So admittedly, they have not submitted. In their affidavit, they have stated.
So it says the right to settlement, right to cancel. It does not say that it shall be cancelled.
In right to cancel, but my lord, that prior to that, these documents.
One question is, was the Bakijai clearance certificate given later?
Yes.
Was it submitted by them later?
By them later.
It was submitted?
Yes.
When? At the time of opening the bids?
No. At the time of opening, they have not submitted.
After that?
After that.
So
it was to be submitted with the tender. Because.
No, but then, you see, one thing, now you look at this, 27.
Yes.
Sailor has got the right to cancel the settlement.
Yes.
Now, the question is it a mandatory requirement or is it an ancillary requirement?
That is their mandatory, my lord. That clause 14.5 is mandatory.
Why do you say that is mandatory?
It is at page 46.
No, Mr. Council, it is mandatory. It'll depend upon the authority which issues the tender notice.
Yes.
They will decide whether it's mandatory or ancillary.
Because in the terms and condition, my lord, it has been reflected that these documents are to be submitted mandatorily.
Where does it say that?
Yes, that is there, my lord. At page 45.
Page 45?
Yes. Papers and documents to be submitted with the tender.
Yeah.
Then here it is 7.4.
Yeah.
Is the clearance certificate. And then the consequence will be, if it is not been done, then here the 14.5 is that this
Yes, what is your case?
Lordship, as per my instruction, Lordship, I will file an affidavit, Lordship.
This is a question of law, not a question of
On the day
affidavit.
of, on the day of opening the technical bid, Lordship, they have submitted, as per my instruction, Lordship, not in, on, or, no written instruction at all now, Lordship. On the day of, opening of technical bid, they have filed a copy of the, clearance certificate that due to has been given due to official reason, they could not file it. So before financial bid, they have.
I don't know, Mr. Counsel, you might not have a very strong case on that point.
My lord.
Because they are decisions of the Supreme Court. With regard to what is an ancillary and what is a
Yes.
mandatory document.
Yes, that is,
Yes.
my lord, I brought it, my
You have,
lord.
you have got the citation.
Lordship,
What is the citation? Just give me.
2020,
Yes,
page
before that.
17.
Please, please, one point.
That,
Yes, my lord. Before going to, I am submitting some all judgment as well as honorable division bench order, my lord. Before that, my lord, your lordship go through my affidavit, page 7.
just a minute. Yes, which paragraph? Which
Please.
paragraph?
Paragraph, my lord. Page, para 7 to 16.
You want me to read the entire judgment?
Yes.
That I'll do later.
When, my lord, the terms and condition contains.
No, this is not the issue. Wait. Yes, for that.
I'm the highest bidder. I am the highest bidder.
No, leaving that aside.
My lord, yes. sir.
Show me,
Yes,
you
my
see, who has to decide?
Decide my already regarding that issue, honorable division bench decided. So I am going to by one, my lord. Before that, my lord, my affidavit is, my lord.
It's 1:05. It is 1:05.
Yes.
While
After lunch.
At two.
Huh? Why are you running away all the time? You come here to run away.
Why the department is
You-
taking time?
Yeah. Have you come here wearing running shoes or something? Then,
Yes.
I'm hearing them. You sit down.
Yes.
Let them argue.
My lord, at two, what case is fixed, my lord justice.
You give me your judgment. Let me see the judgment. What's the judgment? With regard to, you see, the question is,
Yes.
who is to decide what is an ancillary and what is a mandatory
The same,
condition?
my lord, respondent, my lord, in AFDC, honorable single bench, honorable court, they dismiss the petition. And thereafter go to the division bench, division says that Bakizai clearly is not a mandatory.
That is, my lord, the terms
Two
and condition,
judgment, my lord.
terms and condition of the tender, my lord, completely different, my lord.
No, I'm not on that. There is a, you see, the question is, what, now whether a term and condition is ancillary or mandatory, is it the court that will decide or will it be the authority which publishes the NIT that will decide that?
Court is to decide, my lord. There is
No,
such
no.
authority there.
I don't think you are right. I think there's a Supreme Court judgment against you.
Because no such authority is there, my lord, to my knowledge, my lord.
Arre, the authority will be the authority which is spending his own money. Supposing I'm going to spend my money, will I ask A, B, and C permission to do it as I want?
Yes.
My lordship.
Yes.
Hello, my lord, respondent, my lord. Assam Fishery Development Corporation, my lord, regarding this, my lord, next page, my lord. Below that, after considering the rival, my lord.
Yes.
First page, second page, my lord, below, my lord. After considering the rival contention, we are of the view that requirement of submitting Bakizai clearance certificate would not be taken as
Okay,
a
got
legit
that.
requirement.
We got that. That is on one point. But there is a Supreme Court judgment.
Yes, thereafter, my lord, regarding this division bench order, again another division bench was issued, passed, my lord. Yes, my lord.
My lord, complaint was already raised before the authority, my lord. At page 66.
Just a minute, Mr. Counsel, I'm asking him. Just a minute.
My lord. And page, my lord, paragraph 15, my lord.
Paragraph 15.
15, my lord. Paragraph 15, my lord. Page 24. Okay, 15, my lord. Yeah. Page 15, paragraph 15.
Yes.
May I read, my lord? A coordinates of this court in writ appeal number 294 of 2011, this case, my lord, earlier case, and that the Abu Tabil versus Assam Suicide Development Corporation Limited and others. while
Okay,
interpreting
okay,
the
got
order of
it.
the-
Anything else?
Yes, and thereafter, my lord, this is the, because of that, I am the highest bidder, the public interest is there. My honorable.
But
Supreme Court said-
you have still not answered my question,
Yes, ma'am.
actually. These judgments are there
Yes, ma'am.
in your favor, no doubt.
My lord,
But my question is
my lord,
a little deeper.
yes.
Who is to decide whether a condition is mandatory or ancillary?
But they decided by the the director of Suicide Development Corporation. Because of that, at the time of my lord, in the
Who says that? Where is the citation?
Tata Steel.
No.
I'm sorry, but
Show me. Don't guesswork things, huh? I don't know, if you show me Tata Cellular at 2, we'll take it up at 2. If you say it's Tata Cellular, you should never see. Okay, at 2 o'clock.
yes, yes, well, one. I'm sure.
Yes. The lessee will not be able, page 49. Page clause 20.3.
Huh?
Page 49,
Page 49.
clause 20.3.
Yes.
Lessee will not be able to sell or transfer the Min Mahal for catching fish. If such thing comes to light, the settlement.
So
will be
this
cancelled.
is your allegation.
Yes,
So for that, so let the authorities decide.
yes, that authority
That
will
authority
decide.
decide that.
That authority will decide.
But then any other point?
And
One is the Bakijai.
less payment of revenue. Because that we could come to know from the RTI information.
What less payment of revenue?
The revenue is to be paid by them. The
So?
notice was given to them to pay the entire revenue at a time. And that has not been paid completely.
That is between them and you. Who are you? You are not the authority.
But that is a
That
violation.
is, no, that is
a violation.
nothing. That is after they have been settled with the fishery.
Yes.
That is not an issue between, you are not the authority whether they are doing their contract work properly or not. That is not your concern.
That authority will.
You have
decide
got no
by-
right.
Authority will decide all these things.
That is a different issue.
Yes.
That you have got no right.
So that representation is pending before that.
No, forget the representation. Bakijai Palace, you have got no case as per the division bench judgment of this court.
Yes.
With the others, you file a fresh representation if you want.
Yes. So
If any other, but then what is the issue? One is Bakijai, one is Bakijai.
Bakijai side.
Then another thing is subletting. Sublet, so it can be, they can decide, but you have to give proof. You cannot have a roving inquiry.
Yes. So these are my
You
grievances.
see, Mr. Counsel.
Yes.
Subletting, even if it's proved, does not give any right to you to be settled with the fishery.
No, if it is cancelled, my lord, then there
That
will
is,
be retender.
if it's cancelled, there'll be a fresh selection. You've got no right.
I am the second bidder.
Maybe.
Second highest, my lord, I am. Because if it cancel, then naturally the second bidder will.
Those are issues that we don't know. Subletting, so where's the proof that he has sublet?
That we have made the statement and the name of the person also.
Statement is of no use.
Because in affidavit. we have-
Then have you filed a representation to that effect?
Yes, yes.
Where?
Yes, that is there, my lord. Page 67.
No, sublet is, I would reply in specifically mentioned, ma'am.
What have you mentioned?
Yes, ma'am.
My lord, I have given the name of that person also to whom they submitted it, sublet it.
I have not given any sublet, my lord, even. How can he?
One Arvinda
I don't
Das.
know who is he.
My lord, page 67.
No, no, let us be clear. You have challenge on Bakijai, one
Yes.
on sublet, any other ground?
Another ground is, my lord, that is a duplicacy of the PAN card and Aadhaar card is there. Name of the father is
My
different.
name, father name is Sam. I already filed it. Before submitting the NID, I filed a affidavit, my lord.
Stating that your father's name
Yes,
is?
my father actual name is Dulal Das, but it has been shown as Dulal Das in some documents in Dulesor Das. So I filed an, it is same person who is also be proved by an affidavit before the notary public, Lord Lakhimpur, Height Shell.
That's neither here nor there. That's neither, there's nothing.
Issue, my lord.
Okay, right. Heard, Mr.
J. Sharma.
J. Sharma, learned counsel for the petition. Mr. P. Sharma appears for?
Respondent of it. All the respondent actually. Yes, sir. Not to all.
1 to 3, my lord.
1 to 3.
No, sir. In one, Monoj M. Shetty is appearing also. Which are given. Okay.
Yes,
One.
who?
One.
Huh?
One is M. Shetty.
Mr. M. Chetty appears for respondent number 1. Then Mr. P. Barwa appears for
2 and 3.
2 and 3. Then you're Mr.
N. Bora.
Mr. Nilan Bora.
N. Bora appears for respondent number 4. The petitioner is challenging the settlement of the fisheries in favor of the respondent number 4 pursuant to the tender notice number 5/2022. You take this order, huh? Page 9, order dated 9/8/23, second paragraph. Yes, second paragraph. Next. The Mr. P. Barwa, learned counsel for the AFDC.
P. Sharma.
P. Sharma, appearing for respondent number, appearing for the respondents number AFD, for respondents AFDC, submits that though the petitioner, that though the respondent number 4 had not submitted the Bekichai clearance certificate at the time of submission of his bid, the same had been submitted at the time of opening of the tender. Correct?
Financial bid.
Opening of the financial bid of the respondent number 4. Full stop. If-
Say one thing, while while filing the tender documents, he gave the receipt of the application. He
First-
filed with them.
Full stop. He further, the respondent number 4, at the time of filing of his bid, had submitted the receipt / acknowledgement of the application for issuance of the Bakijai clearance certificate from the office of the
Deputy Commissioner,
Deputy Commissioner, North Lakhimpur. Full stop. He further submits that the fact that the father's name of the respondent number 4 was different in different documents had been clarified by way of an affidavit submitted by the respondent number 4, stating that Dulal Das, stating that the petitioner's father's name, which had been wrongly recorded as Duleshwar Das in some document, had been clarified, had been clarified by stating that
Dulal Das.
Dulal Das and Duleshwar Das were the one and the same person. Also. He also submits that with regard to the allegation of subletting of the fishery made by the petitioner, no, there is no proof of the same has been shown to them as on date. Next one. Mr. N. Bora, the learned counsel for the respondent number 4, submits that the Submission of a Bakijai clearance certificate cannot be said to be a mandatory slash rigid requirement, which would entail disqualification of his bid, comma, as the same had been submitted at the time of opening the financial bid of the respondent number 4. Yes, sir. He also submits that the same is that the same has been clearly laid down by the division bench of this court. Next. He also submits that the wrong recording of his father's name as Duleshwar Das in some of the documents. In which document was it wrongly recorded? Father's name?
PAN card and Aadhaar card.
In the PAN card, and Aadhaar card.
Yes.
Of
That
the
is correct. PAN card is focused.
PAN card, in the PAN card of the, in the PAN card of the, in the PAN card of the respondent number 4 was clarified by the petitioner by submitting an affidavit to the authorities stating that the name Dulal Das and Duleshwar Das was related to one and the same person.
Also given at that time, after the Mylord settlement, 50 lakhs bank guarantee also deposited to that
He also submits that 50 lakhs bank guarantee has been deposited
before the,
by the respondent number 4 before the
AFDC.
AFDC. He also submits that there is no subletting of the fishery by the respondent number 4 to any other person. Full stop. I have heard the learned counsels for the parties. Full stop. The issues that have to be decided in this case is threefold. Firstly, whether the Bakijai clearance certificate is a mandatory or ancillary requirement of the bids slash quotations to be submitted by the candidates. So secondly, whether the recording of the father's name as Dulal Das in some documents and Duleshwar Das in some documents would materially affect the bid document of the respondent number 4. Thirdly, whether there has been a subletting slash subcontracting of the settlement of the fisheries by the respondent number 4 to some other person. Is that some other person a party here? No.
But the name we have mentioned.
That you can say anything.
In the representation also we have mentioned the name.
You have mentioned the name. We have not made him a party here.
No, party we have not.
Why?
Party we have not made, my lord, we have not details about.
Okay. I have heard the learned counsels for the parties. No, I've already said that.
Authorities concerned by the video not with division bench, they will say offer who is the author to decide.
Where?
Paragraph
15.
15 means 2016 6 SSC. 2000, sorry, I left it before that. 2016 6
Okay, right.
SSC. Para
In the case of
Para 15.
in the case of Abu Talib versus the Assam Fisheries Development Corporation Limited and others. WA 294/2011, and in the case of Pub Golpara Fishery Cooperative Society versus the state of Assam and 7 others. WA 306/2021, the division bench of this court has held that the Bakijai clearance certificate cannot be taken as a rigid requirement in the tender process. Yes.
Okay, I have something in this Abu Dhabi case.
Huh?
In this Abu Dhabi case, recently also last year also another case was been passed considering this Abu Dhabi case. In this case, no, in this case, this was done considering a single bid system. But here it is 2-bid system. And
So these 2 benches, that's what I said, 2 benches.
no, in Abu Dhabi, this single bid.
No. Abu Tali also is by Justice A.K. Goel and Anima Hazarika.
I have the statement what I have given. So it may affect in my other cases.
Acha, just wait. No. I've got it.
Without referring.
Mr. Counsel, this is the judgment passed by Justice Sandeep Mehta and Justice Sumitra Sakya, and they have said a coordinate bench of this court in writ appeal number 294, Abu Talib. Then, this is not single bench.
Yes.
What have I said?
What logic?
As such, it would be improper to disqualify a bid only on the ground that the Bakijai clearance certificate had not been submitted at the time of submission of the bid. In as much as in the present case, it had been submitted at the time of opening of the tender by the petition.
No, opening of the financial, before financial.
Well, opening of the financial bid by the authorities. Para?
15, madam.
Here, my lord, it was a single bid.
We may add,
Huh?
It was a single bid.
we may, paragraph 15, madam. We may add that the owner or
Yes.
or
First off,
employer.
further. In the case of Afcons Infrastructure Limited versus Nagpur Metro Rail Corporation Limited and another, 2016 SCC 818. The Supreme Court has held that the owner or the employer of a project, having authored the tender documents, is the best person to understand and appreciate its requirements and interpret its documents. Then we just take this para 15, huh? Next para. With regard to the issue of whether the wrong recording of the petitioner's father's name in the PAN card as Duleshwar Das instead of Dulal Das would entail the disqualification of the petitioner's bid, this court finds that the petitioner has submitted an affidavit clarifying the mistake committed by the authorities. And have you asked for correction of your PAN card?
No. As per affidavit, my lord, it stated that, my lord, that my father actual and correct name is Dulal Das, but my electoral photo ID, number so and so, and Aadhaar card number so and so, my father name has been recorded Duleshwar Das.
Okay, it's in electoral ID and Aadhaar card, not PAN card. Not PAN card.
Not PAN card.
Then you say PAN card.
Aadhaar, I'm sorry for that. Aadhaar.
Photo ID and Aadhaar card.
Electoral ID.
Electoral ID,
Yes,
photo ID.
Yes. Voter ID.
Then where is it? Aadhaar card, how come there's a mistake in Aadhaar card?
No, it says that father name be recorded Duleshwar Das.
Anyway, what have I said? Photo ID and Aadhaar card. Come up to the effect that the name Dulal Das and Duleshwar Das pertain to the same person. Pushpa.
Also, I may not be able to express properly in the earlier time, also here, in Abu Dhabi case, there is a single big system, not single big, it was a single big system, Lord.
How does it matter? Single
Here,
bed.
it may matter in other cases, Lord. Here, the facts of the case is that we are in the two big system, Lord. And this case is specially related, in Abu Dhabi case, because level playing was being, in Abu Dhabi case was there, Lordship, here, we have given whether, when there is a Bakija clearance certificate, Lordship, in Abu Dhabi's case, Lordship, in the single branch order, when there is no Bakija clearance certificate, but as because it was single bid system, we opened up all the tender system. As we got all the bid, which even considering the level playing field, we have taken the decision in the case of Abu Dhabi, which is being asserted by the division bench. While dealing with this case, Lordship, in considering this Abu Dhabi case, which was being extensively heard by the division bench, in that case, division bench has clarified that Abu Dhabi case was a single bid system, and this case and this method, all these tender methods nowadays, Lordship, is on. We are not considering the Abu Dhabi case. We are doing dual bid system, Lordship. So here, Lordship.
So what is your case? So you don't.
So here, Lordship, here one part should maybe clarify that Bakija clearance certificate is not an essential document. It may affect us, Lordship.
I have to say that. Well, you take a stand, Mr. Kaushal. You cannot argue both ways. Either you say it is not essential, or you say it
No,
is.
it is essential, but here, Lordship, we have taken the Bakija clearance as an essential document, Lord, before opening up the financial.
Then, if you take it as an essential document, is it required to be submitted at the time of the bid, submission of bid?
At the submission of bid, Lord.
It should be there.
No,
Then,
no.
if it should be there, why did you award him the
Sorry,
contract?
before financial bid, they have.
Mr. Counsel, you cannot, you cannot make submissions. Like what you're basically saying right now is that the Bakijai clearance certificate is an essential document in a two-bid system.
Yeah.
And since he has not submitted at the time of submission of the bid, he has not complied with the requirement of the tender process. If that be so, why have you selected him?
Lordship, because before the financial bid, as per authority, I have done the written article, Lordship. Lordship, I have given a Lordship, it is up to your Lordship, I leave it here.
It is not that, Mr. You have got to think also. You see, there are two parts. Whenever there is conditions put in a tender process, in a tender document, first thing we see is whether it is an essential or an ancillary. Now, if it is an essential document, it has to be there with the bid straight away. Ancillary can be produced later on, depending upon how the authors of the tender document consider it. Now, the division bench of this court in two cases has held that it is not a rigid condition. Now, who are you to say? Either way, you are saying it otherwise. You are saying that no, it is rigid. At that time, they are saying it's not rigid. I don't understand.
But my lord, their document says it is necessary.
Mr. Counsel, their documents will say everything. But what is ancillary and what is essential will depend upon their interpretation.
The representatives before their authority.
Then you go and challenge the division bench judgment before the Supreme Court.
Not that.
I'm the Supreme Court, the division bench in two cases has held that this is not a rigid condition. If it's not a rigid condition, now what to do?
But the fact and circumstances of the cases may be different, my lord.
Maybe. You show me where is different.
Because it is a tender document in which it has been stated that.
Anyway, right, where are we? What's up? As such, this court is of the view that just because of some mistake on the part of the authorities in recording, in making a wrong recording of the petitioner's name, comma. The same cannot be a ground to disqualify the bid as a respondent number 4, comma, when the issue has been clarified by way of an affidavit and not been put to challenge by any of the parties hearing. Next para. With regard to the question of whether there has been any subletting of the fisheries by the respondent number 4 to any other person, comma. The same is only an allegation made by the respondent number, by the petitioner against the respondent number 4. The same cannot be a ground to allot. The same cannot be, the same could not have been a consideration for selecting the successful candidate at the time of comparing the bids of the parties here. Also. Anyway, I'll think about it a little bit more. Hearing concluded, judgment reserved. Huh?
My submission, maybe I noted, my submission is that the representation is pending, that has not been disposed of. Let there be direction to dispose of that, because it is their authority to decide it. And all the questions I have raised there. That's my submission, my lord.
So you want the writ petition to be disposed of?
No, my lord. It may be, yes, it may be disposed of with the direction, madam.
With the direction that your representation should be considered,
By representation.
should be decided by them.
By them.
So I will not make any finding on the subject. That's what you're saying, basically. I can do that. Also, so you just write one thing in the petitioner. Petitioner's counsel submits that the writ petition can be disposed of if a direction is issued to the respondent number 3 to examine and dispose of the petitioner's representation dated
19/6/23.
19/6/23. So then I have to throw away whatever I have dictated. Okay, what to do? If you want to dispose of them, no CAV. I'll correct it.
Bye. Possibly.
But you still type it out.
Wait, please, your lordship.
Put this also. Give me the judgments. Judgments is give it to me. Put it in my all of it.
Lordship, as per the last.
Item?
26, your lordship.
Yes.
Lordship, as per last order, instruction of last order date 12/1/24. As per that order, lordship, I have submitted the extra copies. And probably government was asked to give instructions, bring instructions. Instructions were sought for you. Last order date 12/1. I have served the extra copy there.
Yes, what is this case?
I'm appealing for S1 number 2 to 5 the corporation, your lordship. Your lordship, may kindly peruse the order dated 20/12/2023.
Yes.
The penultimate paragraph, your lordship.
Yes.
After hearing and balancing the equities, it is provided that if the tender process has not been finalized till now, the same shall not be finalized. Your lordship, it has already been finalized before they approach this honorable court. The letter of intent was issued on 18/12/2023.
Show me, where is that letter?
If I receive the inspection, I'll file a detailed affidavit in opposition. Actually, we have alleged fraud being played by them.
Letter of intent has been issued to them.
Yes. To one Monalisa Communication.
Okay, if I submit,
Your lordship takes the judgment order on the last occasion when the notice was issued. There, your lordship, Mr. M. Shetty, London State Council accepts notice on behalf of all the respondents. On the day of notice, when the notice was issued and interim was given to me, that time no such submission was made. And
I mean, he is coming for the first time, Judge. How will he know anything?
this, they, on M. Shetty appeared for all, on behalf of all the respondents on that day.
Mr. Counsel, now, Mr. Counsel, now, how do you prove that Mr. M. Chetty knew what was the, what was the status of the case?
In that case, I will be allowed to, some time to take instruction. Your lordship.
There's nothing to instruct. You
To my
take it,
instruction, it has not been given. Now they are coming up.
well, if
Let
your
us file
instruction
an
is,
affidavit, your
well,
lordship.
what to, no. You challenge this, why you want to waste time?
Yes, in fact, this Mona Lisa communication, they have.
The order of this court is clear, if it has not been given.
Exactly.
No copy has been served to me. Your
We are going to give you, take a photo now.
We are not supposed to give it to them. They are standardized because they have not.
No, you should give.
Yes.
You give to them. This has been done on 18 December.
Yes, your lordship.
And we are filing on 18th.
Look, Mr. Counsel, government,
But
sometimes it happens, what to do?
Weeks time may be given to me.
For what? What are you going to do?
Lordship, the financial bid was opened long back on 6/12/2023. So decided then on.
What are you going to do?
Lordship.
If I give you 1 month's time also, what are you going to do?
Lordship,
There is no stay order anyway.
What is fallen from my friend, that on 18/12 it has been given. On the same day that my interim was given on 18/12.
No, 20.
My
Your interim was given on 20.
Yes, I filed on 18/12.
Whatever, orders were on 20. Now what to do? You have to change your thing now. No, but was the tender process finalized? It's just a letter of
It was
intent.
finalized.
Well, the agreement signed.
Yes, agreement was signed and the performance security was deposited on 26/12. And they have deposited an annual rent for the entire year also.
26/12.
We take it in advance. Everything has been done. It's operating now. They are operating the laws now.
No, but then you see, it says that if the tender process has not been finalized,
It was finalized, Your Lordship.
it was not final. Letter of intent does not mean finalized. Then you have got to sign agreements.
Yes, that was done, Your
When?
Lordship. On 26/12/2023.
That is after the order passed.
And
No, after the order passed, Mr.
the
Counsel.
corporation came to know about this order by way of a letter given by them, which was issued on 3/1/2024. Then only the corporation came to know that this order was passed by this honorable court.
Okay, you file an affidavit incorporating all that.
Lordship.
Okay. Okay, right. Mr.
P.K. Sharma.
P.K. Sharma, learned counsel for the
Respond number 2, 3, 4, and 5.
2, 3, 4, and 5 submits that though this court, while order dated 20/12/23, had stated that if the tender process had not been finalized till 20/12/23, the same would not be finalized and final orders of allotment may not be issued, comma. The letter of intent had been issued to the respondent number?
He was not made a respondent.
No. This, the
Monali-
letter of intent was issued to MS Manalisha Communication on 18/12/23. He also submits that on 26/12/23, Manalisha Communication submitted their what?
Performance security.
Performance security and executed an agreement with the state respondents on
That agreement is not on record, so I'm not sure. That agreement.
no, just say that. He submits that he does not know when the
Generally on the same day, but since it's not on record, I'm not submitting this.
when the agreement was executed between the respondents and MS Manalisha Communication. He also submits that the order of this court dated 20/12/2023 had been communicated to the respondents via letter dated 27. While letter dated
27, which was received on 3/1.
But they.
27 to 23, which was received on 3/1/24.
That are disputed about because their seal and signature is 27/12.
It's okay, but the thing is that, you see, if the agreement has been signed on 26
Very well.
and performance guarantee, everything is done, then you have got no case.
Yes.
But if it has been signed subsequent to that, then, so you bring out the document.
Definitely.
When?
Within a week, I'll file a detailed affidavit in the court.
Instead of that, you bring the agreement, let us see.
Lordship.
You bring the agreement and the deposit of the thing, you just bring your record. When? Friday?
Friday, Lord.
This is a matter of Friday.
Okay, three more minutes.
This is the matter, on which date the respondents council shall produce the agreement executed between the parties along with the documents showing when the performance guarantee had been submitted by the petitioner.
Not by the petitioner, but by Mona Lisa.
By MS Manalisha Communication.
Okay.
Also, the interim documents.
There's no question of interim.
That will continue. The order passed, the interim order passed earlier shall continue till the next day.
May I please, Your Lordship?
27.
Lordship, in this case, Lordship, we have challenged the order dated 15/12/23 issued.
Page
37 and Excel 7, Lordship.
What is this?
This is the attachment order, Lordship.
For what? Because you have not paid what?
Not paid, Lordship.
Not paid what?
PF dues, Lordship.
Provident fund.
Provision fund.
Of your employees.
Of the employee. Lordship, for that, we have already written to the government, and the process of paying the PF dues is already been initiated, Lordship. Within a short time, we will be paying the dues, Lordship. Earlier also, this had happened, Lordship. Earlier also, in earlier cases, Lordship, this had happened. Honorable Court had stayed the order, and later on, when we paid the amount, this has become the Honorable Court.
When will you pay the amount?
Lordship.
When will you pay the amount?
As and when government pays, we'll pay. Then there is.
No, Lordship, this will not, the statement, Lordship. Lordship, this budget, in this year also, the budget provision, the proposal has been taken up, Lordship. Lordship, we have already paid the amount of 20 crores, 29,82,400 that we have stated in paragraph 8, page 10 of the petition, Lordship.
Assam State Transport Corporation.
Lordship. Now, as your Lordship is aware, ASTC doesn't have their own resources of generating this, but only by this way only they are generating their means revenue, Lordship. If these resources are being installed, then it will be problem for the ASTC to give salary to their employees. For the time being, Lordship, it may be state, Lordship. For the time being, I'm not praying for.
Why? What case have you made out for a stay?
Lordship.
What case have you made out for a stay?
Lordship, since the process of paying the PF dues is already been initiated, Lordship.
Initiated. Very good, you're initiating it, but then you give us a timeline.
Yes. Lordship, within August, Lordship, we will pay within August 24, Lordship. This August 24, Lordship.
My lord, give
Because
us a
it
short
is in
date,
the-
we'll file our
because-
affidavit, Lordship. My lord, give us a short date, we'll file our affidavit, my lord will hear it finally.
Lordship, because already process has been
2 weeks may be
initiated and
given, my lord,
this year
2
budget.
weeks may be given for filing affidavit.
Okay.
Moreover, Lordship, we have already filed an appeal, Lordship, which is pending. We have already.
Oh, you filed an appeal.
Lordship.
Then why have you filed this writ petition?
Because appeal has not been taken up since the presiding officer is not there, Lordship.
Why? Not been appointed or what? How is he there?
He is not sitting, Lordship. That is why we have preferred this one. After that, the attachment order has been.
Order, I don't know. Oh, this is.
Means presiding officer is not being appointed, Lordship. That is why
You're changing your stance.
I'm sorry, Lordship. Right.
Where have you said that not been appointed? Let us see your pleadings.
Appeal filed and.
Lordship, page 11, paragraph 10, Lordship. Last paragraph, Lordship.
So non-availability is a different thing.
Non-available.
Non-availability, does it mean not appointed or he's there but he's not available, doesn't come to office? What does it mean?
Lordship, as informed to my colleague.
Yes, you obtain instructions.
Yes.
With regard to this para 10,
Yes.
whether there is an appellate authority, the
Yes.
presiding officer,
Yes.
whether he is there in existence. Okay, then we'll take up. When? You can take up now also. Within 10 minutes, you call up your.
Wednesday, my lord. Wednesday.
Wednesday is a holiday.
Thursday, my lord.
Okay, right. Mr.
SK Chakraborty.
S.K. Chakrabarti, Learned Counsel for the,
Respondent, sir. Provident fund.
all the respondents,
Yes, my lord.
all the respondents submit, sir. He'll obtain instructions with regard to whether
Only.
there is a presiding officer who can take up the appeal filed by the petition regarding non-payment of the EPF
Dues.
pension dues.
Provident fund,
EPF,
pension dues.
EPF dues.
Yes.
Good. This is the matter on Thursday.
EPF.
Let me see the last order passed by this court on 12/1/2024. Because we have given a proposal before the railway. And I don't know whether my learned friend is filing an affidavit or my proposal has been accepted.
Yes, but
That's so far as proposal, that will be considered in due course, but whether under the facts and circumstances of the case, whether they are entitled for interim order, Lordship, may kindly see the terms and condition of the NIT, Lordship.
Let me start with my petition. I'll start. My lord, the tender was quoted by the railway, my lord. And that, my lord, will kindly see at page 23, my lord, will kindly see. 23. This is tender for awarding sole advertisement right of Guwahati station and circulating area. Non-leak over Lumning division. Kindly see 4 mile. Period of contract is for 5 years. This is 25/7/2019. Now, if you see at page 24, tender form, kindly see at page 41. The location at page 41.
Page 41.
41 is the location. 41. Page 41.
Yes.
See, my lord, Guwahati, name of the station is on top.
Yes.
TC Girl Club Circle. These are 1, 2, 3 TC points. Lordship got it. C size 50 into 3, 3 TC point 30 into 15, 2 TC point circle 20 into 20 is 1. That means total 6. 6 hoardings to be placed. This is the disputed question. Now, my lord, in pursuance to that, the hoarding, my lord, we have put the hoardings there from 2019 onwards. Now, the
2019, which month?
2019. This
Which
is
month?
25/7/2019.
25/7.
7 to at NIT.
Immediately
Immediately
from
thereafter.
2012, 2019. period is from 2012-2019.
Okay.
Now, Lordship will kindly see at page 46. A tender was floated by the RLD, Railway Land Development Authority at page 46.
Yes.
At page 46, this is kindly note the date 9/6/2021. Grant of lease for residential cum commercial development railway land for 99 years. That's my lord, is a roundabout where you go in front of that masjid. There's a huge land and they want to develop, and they have given an RFP and inviting some bidders. This is on 2021. Now, at page 49, that is 4/7/2022.
Yes.
My lord, they said that we want to survey, and they have given an offer that what you do it, you remove all these holdings, which you have given TC Point, because this is given to a developer. This is given to a developer by an RFP later on. Then, my lord, they said we will have a joint survey to find a suitable place. Kindly see at page 49.
To find a suitable place for what?
To replace that holding and put in some other place.
Okay.
Now, this is 49. My lord, joint survey. Kindly see at 4/7/2022 is the date. Now, at page 50, these are the places which was given by them on 8/7/2022. These are the places which was given by them. 1, 2, 3, 4, 5. At page 50.
Yes.
Now, at page 51, there is a formal agreement with me, which, my lord, 2019, which starts in the month of December. They made a formal agreement with me at page 51. Kindly see the date.
Yes.
The 17th of November 2022. Lordship got it?
Yes.
Now, at page 54, at page 53, kindly see serial number 9, 10, 11 up to 14. There's a part of the contract at
Page 50?
53. Kindly see 9, 10, 11, 12, 13 and 14.
Yes.
These are the TC Point they kept as it is.
Yes.
Right? Now, agreement by an agreement. Now, at page 54, does the contract, kindly see page 54, 3B, does the contract will be for a period of 5 years commencing from 2012-2019 and will terminate on 19/12/2024. But there is also a relaxation because of COVID, 372 days. Next, C, my lord. Now, in personal care, we deposit the license fees. Kindly see 4E. 4E.
No,
Like-
you see, your earlier contract started.
Earlier, no, this contract is
Yeah,
going on.
no, it started in 2019.
Yes,
You made the agreement only in 22.
they railway made an agreement. I mean, they came forward and they said make an agreement. That's not in dispute agreement. That's normal practice. That's That's normally normally they they do do it like that only.
Okay.
Railway normally they later on, but you have to carry on the contract which was going on.
Oh.
Now, in between, they said that what do you do it? We want to change the location. They requested a deputed person. My lord, your lordship has noted down. Deputed person, but ultimate in the contract agreement, they said no, it will remain as it is. Now, my lord will see at page 54, we paid the requisite fees, license fees we paid. All the license fees has been paid. Some 2-4 license fees has to be paid, but that period is not over. Now, at page 68, they have given a notice to us, vacating that holding
on 14/12/2023. This is the impugn, my lord, 14/12/2023 at page 68. In connection with the matter stated by RLD has previously scheduled the acquisition of designated land in Ambari. This land is intended for subsequent handover to developer. Consequently, RLD has advised the removal of existing advertisement hoarding in the area. To facilitate this transition, and joint survey was jointly conducted by so-and-so representative from a company. Primary object of the survey was to identify suitable location, relocation of the hoarding. We request that you promptly proceed with relocation of the hoarding under the supervision. Please ensure relocation completed by so-and-so. Now, we represented the matter at page 69. See at page 69. We represented the matter. And we said that we had the worst experience earlier also. That second paragraph we said sometime also earlier also it happened that you try to relocate, but we were at loss. Now, this is very interesting. First, second, third paragraph, kindly see. We have given a suggestion to them. This letter concludes with a request for the matter to be taken, expressing the hope for a favorable resolution. We also indicate that if the issue persists, we request you to waive off 40% from our future license fee payment. We said that because it is ultimate. You can't insist because the contract is still in existence. If the contract was over, there's a different period. And ultimately, you enter into a contract knowing fully that 6 per location where again, you said that you continue. I don't mind, take it, but not during the subsistence of the contract. And I said, okay, then what they did, what they have done, kindly see my note at page 71, they agreed. See 71. 28/12/2023 immediately. In view of the reference, you are requested to remove the hoarding from so and so immediately under the supervision as the designated land has been settled for acquisition of so and so land is intended, hand over to developers. Moreover, you are requested for waiver of future license fees currently under consideration. We will inform to you once approval received. These are the approval of the competent authority.
So
Nothing has been done.
So what is the problem now?
Now problem is that we should continue. That's why we.
No, but where is the impugned order or impugned letter?
Yes, has been interpreted by the court.
No, where is it? Where is that impugned letter?
This is the impugned letter at page 49.
Page 49.
At 68, kindly say 68. 68. 68.
Yes.
Now, my lord, 1 second. Kindly see an order passed by this court. What the court has sought for at page 12/1/2024 order. My lord, at page 3 internal, this court is of the view seen the prayer for reduction of license fees under consideration. Till the next date fix, let no coercive action be taken. Lordship got it.
Lordship, whether under terms and conditions, whether we can ask for relocation or not. That is the question, Lordship. Lordship, can you come to page 31?
Yes.
Clause number 11, Lordship.
Yes.
This is the terms of the need, Lordship. The railway administration reserve the right to utilize the space earmarked for advertisement in part or in full as per its need any time during the contractual period. However, the licensee will be given 30 days notice in advance to vacate the service space in part.
Is
or
this
in
a
full.
part of the agreement?
This is a tender documents condition. Same condition has been in the agreement also, Lordship, page 58.
No, Mr. Counselor. You see.
56.
Huh?
Kindly see terms and
No, just a minute. Page 31.
That clause number 12, Lordship. Railway administration reserve the right to modify, alter the location.
Okay, but then you cannot do it just like that.
Lordship, page 50, page 58.
Wait, you're relying upon clause 12 and which other?
11, 12.
11, 12. What else?
13 also, railway reserve the right to replace, reduce the advertising space. All
Okay.
those are made clear.
Now let us see what the agreement says.
Agreement page 58, clause M.
Page 50.
Clause M,
Clause?
bottom one. The administration reserve the right to ask the licensee to shift his equipment, displays, etc. from any location to an alternative location. Without any notice, if it's so required, and such shifting shall have to be done by the licensee at his own cost and compensation is payable to the. So we will be entitled to some way, but that we have agreed. We have said that we will get it. Under the terms and conditions, we can ask for lordship. And moreover, a joint survey was conducted wherein the petitioner's representative was there. His signature is also there, lordship. Page. It's not a unilateral decision taken almost all of a sudden. Page 50, lordship. His
Page?
representative signed at the left hand.
Page?
Page 50. On the joint survey, his representative was there. He signed the memo, lordship. Joint survey memo. Page 50. The first signature on the left hand side at the bottom, lordship. So under the terms and condition of need, under the agreement, we are entitled to ask them for relocation. Only things that we have assured him that some waiver there, that will be done as per entitlement, lordship. So for relocation is concerned, we can ask for them, lordship.
You take a decision on this page 71.
That is for waiver of license fee only. That is we are ready to do any time.
So
But
you-
for that, we cannot put that
No,
on
no.
preconditions,
You
lordship.
see, to decide the entire case, unless you take a decision on this, then it's very difficult.
That cannot be in my submission, can be in a precondition to ask them to.
No, it's not him. I am saying it. This court is asking you
Okay.
to take a decision on this. You take a decision on this, then because we cannot decide the issue.
Yes, there exactly, there
Unless-
is arbitration clause also there.
No,
Agreement.
we cannot decide this issue unless you decide this request made, the proposal made by the petitioner regarding waiver of future license. How do you know? Your clients may agree to it also. Then
They can reject also.
they can reject also. So let's take a decision.
Whether they
When?
precondition lordship. Lordship will be after 2 weeks, lordship.
Correct. Take a decision on this, then we'll decide the entire matter. Heard Mr. Shri D. Daslan, Senior Counsel for the petitioner. And Mr. M. Bhattacharya,
B Chakrabarti.
B. Chakrabarti, sorry, B. Chakrabarti, that is CGC. That is CGC. Mr. B. Chakrabarti shall obtain instructions with regard to whether with regard to the status of the consideration for waiver of future license fees, as reflected in the letter dated 28/12/2023, issued by the Office of the Divisional Commercial Manager, Guwahati. Bracket para 9, annexure 9. Leaves the matter after 2 weeks. Interim order passed early shall continue till the next.
Document fix a date, lordship.
Okay, give a date. Date.
Well, Diplio.
May it please go. In this matter, well, it's a tender matter. While issuing notice, liberty was granted to us to renew our interim prayer. In fact, tomorrow being the last date, in abundant caution, we have also filed an IA for extension because they have in the meantime filed the affidavit. We have also filed an IA for extension of the last date in case your lordship wants to hear the entire matter. The
So far as I is concerned, my lord, I have got some preliminary objections regarding maintainability of the IA. But if the, my lord, entire matter is taken up, it is up to your lordship, my lord, we have filed our affidavit. But the state government and Union of India, they are actually formal parties. They have not responded yet.
Some further affidavits for final disposal, some further affidavits might be required. But so far as the interim is concerned, my lord, your lordship may have perused the first order. But while issuing notice, this is an order of 12th of January. Perhaps considering the fact that there was some time left for the last date to arrive, towards the end, your lordship will find last but one paragraph. In that view of the matter, it is provided that the petitioners would have the liberty to submit the bids, which however will be without prejudice to etc. etc. The interim prayer may be renewed on the next day. Now, my lord, issue is not very long, although the brief looks very bulky. And your lordship is aware, the law is very clear that otherwise the employer has the right.
What is the issue?
That is what I'm coming to. Otherwise, the employer has the right to fix the terms of invitation to tender. However, the only qualifying this thing is criteria is that if it is so tailor-made to suit a particular person or a class of person. This is a case, my lord, classic case of that. If I may, without taking much time, my lord, if your lordship will kindly come to the NIT itself, I'll quickly point out a few clauses. Your lordship will first turn to, there are page 74. Man.
Okay, what is the prayer now?
Prayer is for, my lord, stay of the tender process, because it is out and out, my lord, tailor-made to suit a class of person. We are transporters. They are bringing in distributors, well and good. You have to bring in distributors, well and good. But treat them at par, which you have promised in the NIT. That is what I was pointing out to your lordship. If your lordship will first come to page 74, the second para, the last sentence in the second para. It's a sentence starting, Indian distributors may also participate. Has my lord got that?
Yes.
Indian distributors may also participate in this tender for other than their own loads, and they shall be treated at par with other transporters. This was otherwise not even required, but they are themselves saying that you will be treated at par with all other tenderers. However, what they do is this. If your lordship kindly turns to page 80. So, clause E. What is own-use trucks is clarified here. IOC reserves the right to induct trucks belonging to Indian distributors for carrying their own loads at the L1 rates being finalized against this tender. What they are now indicating very subtly is someone else might quote a L1 rate, but we'll give the work to the distributor. And then further one, own-use trucks referred above are those trucks already offered by Indian distributors for carrying their own loads for operating in established L1 rate being finalized against this tender. All other terms and conditions of the tender shall be applicable for own-use trucks. Now, if your lordship kindly turns to 178 one. Clause 5.
Yes.
Trucks will be first allocated to Indian distributors qualified for own use trucks at L1 rates. Now that subtlety is disappearing. Now they are making it very clear that even if someone else quotes a L1 rate, we will give it to the distributors first. Starting from lowest age of the truck till the requirement is met, all the trucks qualified for own loads will be listed as per ascending order of their age. Now, the other interesting thing, which your lordship will find at page 197.
Yes.
The lordship kindly comes to security deposit.
Yes.
Your lordship will find there are two classes now made for even for security deposit. Contractors placing only category 1 trucks, 8.4 lakhs is the security. And for trucks under own use category, security deposit of 50,000 with a maximum of 2 lakhs.
So on the one hand, you are taking more security from the other tenderers, and
What do you mean by contractors placing only one category one truck?
all the other trucks would be category 1.
What does it mean? Does it mean
They
that-
have laid down
that-
certain
No, does it mean that these contractors do not have trucks of their own or what?
They may have, or they are also calling some attached trucks. But what they are doing is, they are giving a preference to, they have defined own use trucks to mean trucks owned by the distributors. So they are asking for a lesser security deposit from them. On the other hand, they are saying that even if you don't quote the L1 rate, you'll get first preferred. And then it does not stop there, my lord. If your lordship will now come to page 195.
This
Page 195, they have laid down absolutely stringent conditions even after getting the contract for the transporters, which are us, the other tenderers who are not distributors. None of these conditions are applicable to any of the distributors. So virtually, they are giving a walkover to these people at our cost. Your lordship will, I'll just indicate one, my lord, clause. Your lordship will kindly come to clause 1.6.
Yes.
The trucks attaining the age of 15 years or as stipulated in NIT during the contractual period shall be removed from the contract. Replacement within 30 days with another truck having age of less than 15 years shall be the responsibility of the construct transport contractor. It is not applicable to distributors, only the transport contractors, which are us, failing which action as per contract agreement will be taken. Similarly, this page is full of such conditions which are not even applicable to distributors. But virtually, they have designed the tender in such a way that the distributors will walk away with virtually all the contracts. So, if it is so tailor-made, your lordship is aware of the law, my lord. Mirror development makes it very clear that otherwise, you have the full handle as an employer, as a tender inviting authority, you have the full license to lay down the terms of invitation to tender. However, it cannot be, the rider is that it cannot be so tailor-made to favor one class of people and to oust another class of people. Now, may I place the judgment straight away, my lord, the paragraph? It is in that very limited ambit, my lord, this repetition has been filed. It is absolutely tailor-made. And if your lordship, since we are at the admission stage, I am not troubling your lordship with each of the clauses. At page 195, your lordship will find there are numerous stringent clauses which are applicable to the transporters, but not applicable to the distributors at all. The citation
But
is,
isn't these rates that are to be made, isn't this rates for the benefit of the public?
certainly, all contracts are, my lord, ultimately for the public. But that
So
does not,
isn't it to get the best possible rate?
rate, that is what they are not saying. Otherwise, what is the purpose of a tender? It is always to get the best possible rate. Therefore, the concept of L1 arises that who quotes the highest or who quotes the lowest, as the case may be. Now, assuming I am a transporter and he is a distributor, I quote 10 rupees and he quotes 15 rupees. He will get the first preference, being a distributor, to give it at my rate. So I will quote the viable rate which I assess to be, as a prudent businessman, which I assess to be would be the lowest, so that I get the contract. Now you will take the rate from me and you will go give the contract to him. Can that be permissible? That is the question before your lord.
I think that's being done by this FCI and all. For transportation of rice and all, food grade. I think they're doing that.
But
no, look into it.
But for the purpose of preparing a class of separate class altogether, can it be done? That is the question, my lord. If your lordship will just have mirror development for a moment, 2009 6 SCC 171.
Yes.
I am relying on the last sentence of the paragraph, but I'll read it from the top part. A tender is an offer. It is something which invites and is communicated to.
Now, where are you reading?
Para 26.
26.
A tender is an offer. It is something which invites and is communicated to notify acceptance. Broadly stated, it must be unconditional, must be in the proper form. The person by whom tender is made must be able to and willing to perform his obligations. The terms of invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in the realm of contract. Now, next sentence. However, a limited judicial review may be available in cases where it is established that the terms of the invitation to tender were so tailor-made to suit the convenience of any particular person with a view to eliminate all others from participating in the bidding process. This is the area in which this writ petition has been filed. We are invoking this particular mandate of law that you could not have favored someone, a class of people, the distributors in this instant case, and for the purpose of ousting us. And these clauses, my lord, when read together, your lordship will find that it is so tailor-made to suit their convenience that they will simply walk away. We will be, where will our Article 14 be? Where do we get the non-discriminatory treatment, a fair treatment by the authority?
There are other ways of looking at it, maybe. Supposing a private contractor's rate is accepted and he doesn't have trucks of his own. Then what happens? And then say okay, for the first few months, he's able to.
No, without having a truck, I can't even participate.
No, but then you can have an agreement with some other truck owners and take their trucks.
No,
You have to
that
have
is
your
not
own,
permissible. All those things are taken care of with the tender.
do you have to have your own trucks?
Yes.
You have to have your own trucks.
Yes. All even be it that is what I'm saying, my lord. Otherwise, it is a ceteris paribus situation, my lord. All other things are constant. It is only that when you are fixing the security deposit, you are giving them a benefit of a huge margin. You are taking a much higher amount from us, then giving preference to that class of people. And at the same time,
So there has to be a justification for that.
But the whole idea behind the tender process is, as your lordship is aware, the only limited protection that a tenderer has is of Article 14 and 19(1)(b), which mandates non-discriminatory equal treatment. It is only that limited area where your lordships normally intervene. Otherwise, the employer has the absolute authority to fix the terms of invitation to tender.
What do you mean? What is a distributor? What is
Distributors are their own distributors.
Their own distributors.
Who are into the retail distribution of LPG. So they have, it is like a situation that you have been associated, you are close to me, so I'll favor you, give you some extra favors. But you are handing out state largesse. You cannot, you are after all the mighty state. You have to act fairly. And my lord, the other aspect is, if you even, I must indicate to your lordship that they have already extended it of their own. So no great prejudice will be caused to them, even if the date is extended and the matter is finally heard. Because the original date of last date was 1st of January. Now it has been, they have themselves extended it to 31st of January.
Yes, so what to do?
My lord, first thing I'd like to know, my lord, whether he is pressing the IA or he is pressing for the interim order, because the prayer in the IA and the prayer in my lord, the interim prayer in the writ petition are mutually exclusive. One cannot exist in presence of the other.
IA is the alternative. Our main prayer is for an interim protection.
I have to
Tender
be clear
process.
which I am arguing, whether this extension I am arguing or in the main writ petition interim.
If you are ready, we can fix it for final year.
Yes, my lord, I'm ready. In fact, today also your lordship may take up, my lord, I have got filed the affidavit in opposition. But the question is, my lord, I'd like to apprise your lordship, my lord, these 16, my lord, the contractors, they were inducted as contractor in 2014. That was for a period of 3 years. Then, my lord, there was a provision of extension for 1 year. So they have run from 2014 to 2018. They are doing their business. In my lord, 2018, we have again, my lord, floated the tender. They had resorted to strike. And my lord, we are compelled to, my lord, cancel that. Then, my lord, we had again done it in 2020. Then, my lord, again hesitation and various pressures, my lord, muscle techniques have been used. Oh no, this is on my affidavit. on my affidavit, I'm not submitting anything beyond what is there in the, in our pleadings.
Master is not in there.
Then, my lord, the 2018, 2020, and then, my lord, there have been many negotiations. And then, my lord, further, actually, my lord, the next, my lord, the NIT was issued in August 2020, April 2021, June 2022. Every time, my lord, they resort to strike. And, my lord, there have been, my lord, many negotiations. So, my lord, from 2014 till date, my lord, they are, my lord, operating. They are, my lord, some of the operators. It's not that, my lord, they are the only operators. And they have got an association. And that association, or while moving this petition, on the previous day, my lord, they had resorted to a flash strike. Then, my lord, this honorable court did not pass any interim order. That was brought to the notice of the honorable court. Either you go for strike or you come to the high court. You cannot have both. But they continued for 2 days. And this has been affecting the, my lord, the public interest. We are, my lord, supplying the LPG to the consumers. Now, no, they did not propose. I'll show that. Please let me, I did not disturb when the submissions were made. If you want to counter it, counter it. Now, 2014, this is their tactics, my lord. Every time there is an NIT, my lord, they resort to strike. And, my lord, eventually there were, my lord, many negotiations. Even the state, in the, my lord, the Civil Consumer Affairs and Civil Supplies Department, they were also brought in. And there have been several negotiations. And eventually, my lord, after many requests, we have been requesting them that you participate.
Okay, Mr. Chaudhary, one thing. If you all are ready to hear, we can fix a date. Or do you want to do it? I do not know. Because I think we'll have to decide. Pleadings are complete or not?
Two parties. I think Union of India is State of Assam and Union of India are yet to do. State of Assam stand would be critical with this case because they have been party to some of the.
No, I'll show their document, my lord. In the tripartite, my lord, MOU, it has been agreed that whatever has been now fixed and that will be accepted by them. I have got that document to show. Now, every time, my lord, last moment they come and they want to stall it. And they're to run from 2014 down also. My lord,
So according to you, state government not necessary, affidavit not necessary.
No, state government has not filed the affidavit, but the tripartite meetings, my lord, minus I have annexed. If I may draw you.
So that is enough. According to you, that's enough to decide the issue.
No, according to that, my lord, the matter was resolved. Matter was resolved. In fact, my lord, the last date was 31st of December, and on the request, we have then again extended up to, my lord, 31st of January. And what only ground, my lord, asking for the extension is that, my lord, we did not get time to prepare. From 2014, you were running. There have been 3 more NITs. At your instance, those have been cancelled, and you don't have time to prepare. And, my lord, your lordship will kindly see that correspondent. My lord, sir, there. This is an absolutely frivolous petition. My lord, they want to continue with their earlier contract. Now, if your lordship kindly comes to
No, one thing. Let us be very clear. Are we going to decide the entire matter or what?
My
What
lord,
is the
if your
issue?
lordship takes time, I'm ready, my lord, because 31st is the last day. And, my
Yes.
lord, 31st, we cannot, my lord, even extend for a day. Because I have shown, my lord, we require at least 4 months' time to finalize. But because of this, my lord, their current extension is up to 30th of April. 30th of April. Therefore, my lord, this period we require, and we have given a chart, my lord, in the objection to the IA, why this time is required. If your lordship kindly takes up my objection at page, my lord, 65, your lordship will find, my lord, these are the things to be done.
No, that's okay. No. I'm not on that. You see, can we dispose it off? You want to dispose of the entire writ petition? Or
My
you want to
question, my
dispose?
lord, my prayer would be your lordship will dismiss the writ petition after hearing both the parties, my lord. And, my lord, there cannot
you are
be any
ready?
extension.
Can we, states, because state has a stake in this matter. Unless state says
Who is
that
for the
we
state?
don't want to file.
Who is for the state?
Food and Civil Supplies Department is the nodal authority, and their stand would be crucial in this matter. Unless they put it on record that they don't want to file an affidavit. But how, after notice having been issued, they have to at least say that we are not filing an affidavit.
Let us see that. Yes, who is for the government?
I don't know, yet will be accepted by them. They have accepted it. Pays chief.
This a very simple question.
Lordship.
Are you filing affidavit or not?
Lordship, as the matter is urgency, we will go by the memorandum of understanding, Lordship, MOU.
So you are not filing any affidavit.
Well, Lordship will record that in that case and even let them, even proceed. Let them not finalize, my lord, till the matter is heard.
No.
Because it is their own case. Two things that has come out from my learned friend's arguments is only because we have purportedly resorted to some strikes, we are going to discriminate against you. That itself violates Article 14, number one. And number two, it is their own case that since 2014, we are just these 16 people have been running. So another 2 weeks or 3 weeks, how will it matter?
It does matter, my lord. Even 1 day matters.
It is their case that since 2014 we are functioning. Another 2 weeks will not make a.
Okay, we can hear it tomorrow.
Yes,
tomorrow onwards.
I'm ready, my lord.
Anytime after 5th one. From tomorrow I am away for a week.
But without any interim order. And if the most your lordship may say that, my lord, the finalization will be subject to the result of the case, that to that.
Let them
extent I
proceed,
agree.
but let them not finalize.
No, my lord, finalization means again, my lord, they'll extend. Because we require this time finalization. From, my lord, the 30th of April, they want to further extension. That is the, my lord, tactics they're using, my lord, all these years.
April is, my lord, 3 months away.
3 months, I have given the chart. Your lordship will see what are the things we need to do after the, my lord, last date of submission of the bill.
Let them proceed with this.
I have given your
Let
lordship.
them not issue final orders. That is all I am asking for.
Page 65, your lordship will kindly see, my lord. These are the things to be required to be.
Page?
Page 65 of the, my lord, the objection to the IA. And my lord, one of the petitioners is the president of the association. And my lord, they resort to strike on the previous day of moving of the petition. And my lord, he is also a petitioner here, individually.
There is no strike.
There was strike.
But when they put us at gunpoint, can't we
They
even
want to
say
put
that
us
we
at gunpoint, my lord. They want to, all these.
tender
years-
itself is at gunpoint.
Otherwise, my lord, I would
It's a
not have
threat.
objected
Yes,
this
yes,
one.
just a minute. Page 65.
Page 65, your lordship will see, my lord. Time for, and that is the guidelines of the, my lord, the vigilance department. That, my lord, it has to be done within a time period. What is the time to be given? Now, the timeline has been given. The, my lord.
Page 65. 165 or 65?
Page 65 of the objection, my lord. Objection to the IA.
Yes.
Floating of tenders is, my lord, 24/11/2023. My lord, I asked myself this question, what have you been doing all these days? It was floated on 24/11. And you have the filed a petition only on, my lord. Petition was filed.
Notice was issued on 12th of January.
On
Must
10th
have
of
prior
January,
to that.
10th of January, my lord, the NIT was of 24/11, number one. Then your lordship will see opening of technical bids, that is the date given, scrutiny of the documents submitted by nominated officers, then online verification.
So the issue, the selection is still some time away. It's a final selection. Now the only process is, the process is here.
That is what I am saying, man. Let them.
So
not
we'll
finalize.
fix it on
But your lordship must be satisfied that, my lord, they have got certain grounds. Because, my lord, the author.
We'll fix it on 5th.
6th. 5th, I am coming back.
Yes, because
Lordship will-
in the meantime,
I will
the
take it.
finalization will not be there.
We'll fix one.
6th is a Tuesday. Your lordship will fix it on 6th.
Right.
And let them not take any precipitating action.
No,
Let them go ahead.
No,
Let them go
no,
ahead.
they will follow this timeline.
Yes, we'll follow this timeline. This,
The
will not-
timeline, they'll follow it.
Your lordship may say, my lord, we'll follow this guideline.
We won't be able to participate in that case.
Why?
If our grievances are not met.
Fine.
The only ground in the IA is that they have not been, because of the litigation, they have not been able to prepare themselves for
You
filing.
see, scrutiny, you see, opening of technical bids will be done on 2nd. And scrutiny will be done on 10th.
So 6th, your lordship will hear the matter.
We'll fix it on 6th.
Your lordship will grant us some limited protection.
What is the protection required, your lordship? They have to satisfy, my lord. What is the product? We are not issuing the, my lord, the.
If anything happens during the opening of technical bids, you can always come by way of an IA. If anything happens.
No, that's why I asked Malad whether you are pressing the IA because the prayer made in the IA is over there in the Malad main writ petition. If the extension is granted, that means that they were accepting the conditions in the tender.
Anyway,
If you
right.
accept it, Malad, the writ petition becomes
Heard
infructuous.
Mr. Indrajit Chaudhary, learned senior counsel for the petitioners, and Mr. M.K. Chaudhary, learned senior counsel for the IOC. Pusta. On the prayer of the parties, list the matter on 6/2/23 for admission hearing. Pusta. Mr. K. Gogoi, learned counsel for the Food and Civil Supplies Department, submits that they will not be filing any affidavit and he will rely upon the tripartite agreement made between the parties in support of his submission. Pusta. Accordingly, on the prayer, the parties list the matter on 6/2/23 for admission hearing. It is the respondent shall also stick to the timeline for finalization of packed transportation tender in terms of annexure bracket PF annexure P6 of the
Here,
Objection.
they are scheduled to open it on 2nd. Let
Yes.
the opening be deferred till 6th month. Only
How-
4 days.
How will it matter? There's nothing. How will it matter? They only open it.
But the moment they open, the third party rights will come in, Malad, their prices will be known and all those things will come in. Your lordship will defer the opening till 6th month.
My lord, I strongly object to that, my lord, then the your lordship will
How
hear
does
on
it
the-
matter?
But
How does
my
it
lord, if
matter?
your lordship says,
Prices will be known anyway later on. They have to open it anyway later on.
later, if on 6th, because otherwise the rates become known, various complications come in, Malad. If your lordship will kindly see, to their own chart, Malad, page 65. They are saying, there is a date fixed for 2nd of February for opening of the bids.
Yes.
And they scrutinize the documents only on 10th.
Yes.
So if the date of opening is deferred till 6th.
No, they have got to make comparative charts and this and that. Some official.
Unnecessary complications might come in, Malad. There will be more parties jumping in the fray. But
What more
ultimately,
parties? All the tenderers have got a right to participate in this
And
thing.
they have been given the right to participate, my lord, liberty to participate, they will participate.
And there'll be nothing. Right. Whatever we said. P6 of the written objection filed by the OP number 123 in IAC number 255/2024.
Minutes.
Minutes, huh? It's a tripartite minutes.
MOM, my lord, minus.
No, that's all.
Highly obliged.
right. In that case, your lordship will just write that, add a rider, Malad, that any action taken will be subject to outcome of the review.
My lord,
That can be added, Malad. That,
my lord, nothing is going to happen till 6th, my lord. They may renew this prayer if necessary on 6th.
I have
No,
now,
we are going-
you
your
can
lordship is
consider to
going
the
to
extent,
dispose of the
Malad.
matter, my lord.
Just any action taken will be
No,
subject to
for my
outcome.
lord, on that, my lord, your
That is
lordship
always there, Malad.
Your lordship has to be prima facie satisfied that they have got a case. From
Satisfaction, I think.
2014, 10 years, my lord, they're running the business and they want an extension. On
We are not, I am not on the
extension.
extension anymore, Malad.
Just right, any action taken by the respondents will be subject to the outcome of the writ petition.
Obliged.
Yes.
Lordship,
Yes.
I'm before your lordship because my previous license was suspended. Your lordship, I ordered dated 8/1/2020. Therefore, your lordship, by order dated 22/1/24, this honorable court has sought instruction from the respondent whether my license can be kept in suspension for a period exceeding 90 days, which is in violation of clause 15(2) of Assam Public Distribution of Articles Order.
See, it is already cancelled in 2020 itself, lordship, and it was also communicated to the petitioner, lordship. Again, against this also, he has preferred a lordship petition before the honorable chief minister. That was also taken into consideration, lordship. I have received the instruction, lordship. And Metavika in fact, he is challenging the suspension order, lordship. It was already cancelled in 25/3/2020, lordship.
He challenged the suspension order of 8 January
8 January, Lordship.
and it was cancelled on it was cancelled on 25th March,
Lordship,
2 months later, Mr. Council.
Your lordship, that has not been communicated to me.
Anyway, now it's communicated.
Yes, your lordship, if that is the case, then why they have again issued a reminder so cause notice on, on 10/8/2023.
That was done on the basis of that was done on the basis of the petition filed before the Honorable Chief Minister, Lordship. And it was also reflected in the last page, Lordship. My lord may kindly peruse the last page, Lordship.
So your lordship may read
Lordship,
the content of that notice, your lordship, page 37.
If required, I can file affidavit. Otherwise, matter was infractuous, Lordship. He is challenging the suspension order, Lordship. It was already cancelled, Lordship.
The lordship may peruse page 37. Nothing has been mentioned even in this notice, your lordship, regarding cancellation, your lordship.
No, the last page is what?
Your lordship, page
Just a minute.
Lordship, Lordship.
Oh, yes. Sir, it has been cancelled. There's nothing remains.
Your lordship.
You challenge this order. What remains? There's an order here. We'll give him a copy of the order.
Lordship, I'll supply, I'll supply.
Right.
Your lordship, in that case, your lordship, if your lordship peruse, page number 37, your lordship. It is.
Page 37.
Page 37.
Yes.
It was issued on 10/8/2023.
Ah.
Your lordship, it is the ditto same so-called notice that was issued to me after my license was suspended, your lordship. Even in this notice, nothing has been mentioned that my license was cancelled. Before that also, I have filed representation after representation. nothing
Yes,
has
what
been-
about this page 37?
Your lordship,
Page 37 is, Lordship, it is reflected in the last page I have given, Lordship. On the basis of the Lordship, representation submitted before the Lordship Chief Minister.
Okay.
Lordship.
No. Is it? No, in the last page it's not reflected.
your lordship,
Otherwise also, Lordship, license was already, Lordship, cancelled, Lordship, in 2020 itself, Lordship.
It's not reflected, Mr. Council. Why are you saying reflected?
I don't mind. That so-called was not reflected, otherwise, Lordship, it is already cancelled, Lordship.
Then you said that it is reflected. Anyway, you have challenged the suspension after 4 years.
your lordship, I have not, I have challenged the suspension because I was of the view that my representation were not being considered. And I have been suspended, kept on suspension for 4 years. And your lordship, if they have cancelled my license, they ought to have communicated to me because my right to appeal under clause 29 has been taken off, your lordship. Because your lordship, if I have known that my.
We'll give you time, you challenge that, we'll
Yes,
give
your
you the
lordship,
liberty.
condone the delay and in the
Do
meantime,
that.
I may file, I may be allowed to file.
I have no
your
question,
lordship.
Lordship.
Right.
If he is no any knowledge, Lordship.
I had heard Mr. I was saying learned counsel for the petitioner. Also heard Mr. K. Goel, learned counsel for the state respondent.
Lordship, Lordship.
The petitioner's case is that the petitioner's fair price shop was suspended on 8/1/2020. And he was issued a show cause notice on 27/1/2020. The petitioner thereafter submitted his reply. However, no decision was taken on the petitioner's reply, and the respondent authorities continued to keep the petitioner's fair price shop under suspension in violation of clause 15 of the Assam Public Distribution of Articles Order, 1982. 15 bracket 2, 15 bracket 2. Next paragraph. The petitioner's counsel further submits that the petitioner was issued a further show cause notice dated 10. Where do you get 10?
Your lordship may come.
Dated 10/8/23. Issued by the additional district commissioner, Food, Civil Supplies and Consumer Affairs, Sonitpur. Asking as to why legal action should not be taken against him in terms of the Control Order and Essential Commodities Act, 1955, in view of illegalities committed by him in not maintaining his stock and price board, distribution of rice, etc. He submits that a fair price shop cannot be kept in suspension beyond the period of 90 days without issuance of mandatory notice under clause 15 bracket 2 of the Assam Public Distribution of Articles Order, 1982. Next paragraph. Mr. K. Gogoi has submitted order number SSM /4/FP shop /2020/2000 /203 dated 25/3/2020, issued by the Deputy Director, Food, Civil Supplies and Consumer Affairs, Sonitpur, which states that the petitioner's fair price shop has been cancelled in exercise of the power conferred under clause 15 bracket 2 of the Assam Public Expense Assessors. He accordingly submits that the writ petition should be dismissed as infracted. Next paragraph. Mr. I. Hussain, learned counsel for the petitioner, submits that if the petitioner's shop had been fair price shop had been cancelled in the year 2020, then what was the need for the state respondents to have issued a subsequent show cause notice on 10/8/2023 to the petitioner, asking as to why legal action should not be taken against him. The petitioner's counsel, however, submits that as there is an order of cancellation of the petitioner's fair price shop in the year 2020, he will not be having the
Right to appeal.
Under
Clause 29.
under clause 29 bracket 2 of the order says so. He submits that liberty may be given to him to appeal the impugned order dated 25/3/2020, as the same has been made known to him only today. Mr. K. Gogoi, appearing for the state respondent, submits that he has got no objection to the prayer made by the petitioner's counsel. Next paragraph. The order number 555M. Is it or SSM? Will SSM or 555M?
SSM lordship.
SSM slash FP shop slash 2020/2003. No, 203. Dated 25/3/2020. States as follows, huh? Take it down. This one, this yellow. States as follows. In view of the consent of the parties, comma, this red petition is disposed of with liberty being given to the petitioner to challenge the order under clause 29, so, 29(2) before the appellate authority, comma, within a period of 30 days from today.
Today, lordship, it will be
With
30
a
days.
period of 30 days from today. Full stop. In the event the petitioner files the same within a period of 30 days from today, comma, the appellate authority shall consider the case of the petitioner for condonation of the delay, which has been occasioned, which delay has been occasioned due to the failure of the state respondents to provide the cancellation of the order of the petitioner's fair price shop. The order cancelling the petitioner's fair price shop only today. We'll give him a copy.
Lordship, I have already submitted. I have already submitted. My lord, may take it a part of the record, lordship.
The entire thing or the?
Entire
Okay.
thing, lordship.
The order dated 25/3/2020 is made a part of the record and marked as an extra X.
Another thing can be added, your lordship. My
Yes.
appeal may be disposed of within 90 days.
It will be as per lordship.
Because they may again.
In
extend
the
it
in
for
the event,
another
in the event, the petitioner files an appeal before the appellate authority. It is hoped that the appellate authority shall dispose of the appeal expeditiously and preferably within a period of 3 months from the date of receipt of the appeal.
After 3 months, lordship may indicate 90 days. We have-
90 days.
90 days.
How does it matter 3 months, 90 days? Huh? No difference.
Some month, lordship, it was 31 days, lordship. As per the rules, lordship, it should be 90 days, lordship.
Next. Yes.
My lord, in this case, my lord, it's really.
Oh, yes.
In this case, lordship, we wait for instruction. Otherwise, we have written, so lordship may give some time. Otherwise, probably some decision is taken. It's because lordship hearing was also concluded, lordship. So course has issued, he has replied, hearing was concluded, lordship. Lordship may give another chance, lordship, we will obtain instruction. lordship.
3 months have passed.
Yeah, it is true, lordship. Whether there can be decision is also taken or not, lordship. They
So
probably-
wasn't it your duty?
Probably, so lordship, we have written to the authority, lordship may give another chance, we will place it.
We'll listen on Friday
Lordship.
or Thursday.
Thursday,
Thursday. Friday.
Because they have to issue a notice that is.
Lordship
also
may on
notice
fifth,
for extension. We have-
No, fifth, we are fixing too much. We've already fixed the
All
number.
two, lordship, Friday, lordship.
Okay,
we
Friday,
will-
right.
No, it is.
Mr. K. Gogoi shall obtain instructions with regard to the status of the, as to why the petitioner's fair price shop license has been suspended beyond 90 days. Any good problem. Full stop. List the matter of Friday.
My lord, I'm sorry, my lord, I was not present in the court when the matter was called
Yes.
up to the first class, my lord. Sorry to my lord, if I also keep you waiting. Now, my lord, one question, your lordship, had been foreign from your lordship regarding the arbitration clause. Now, your lordship is aware, my lord, the constitutional powers of this court cannot be fettered by an alternative remedy.
That is there, no doubt. But
On
there's
that, my lord, one decision, if your lordship may like to peruse the matter. Now,
no, so let us, harp on this issue. Yes, which para?
Paragraph 33.
33.
34. Plus B is my lord. Plus B.
Yes.
This was my lord regarding a contract of railways, my lord.
No, I'm okay with that. The proposition of law is there. That we are, it's untimely, our power. But the thing is that when there is a dispute with regard to whether this station should be it should be decided as to the place from where you should transport the goods or not. Let them decide. Why should we take up the issue?
They have already decided, my lord.
So you go.
Initially, my lord, they had allowed.
Oh.
It was forwarded, my lord. We submitted an application because the rules permitted. Under the rules, my lord, earlier also we had made a request near a station in Delhi that was, my lord, allowed. And here in near Kolkata, my lord, we had great difficulty because the facilities were not there. And we wanted to, another, my lord, nearby station. That application was forwarded. And my lord, no objection was also received from Eastern Railways. And thereafter, my lord, Railway Board rejected. My lord, one of the points, my lord, that I'm urging is that for termination in the contract itself, my lord, there is a clause that for termination you have to give 2 months notice. That notice has also not been given. May I draw your lordship attention to that?
When was the termination done?
Termination is, my lord, 11th of August 2023. And this honorable court was pleased to pass an interim order, 2 interim orders, in fact, my lord. The respondent shall not take any coercive step against the petitioner in deference to the order of termination that is dated, my lord, 16/8/2023. And my lord, there is another order where, my lord, this honorable court directed that they should not go for fresh advertisement. Now, what happens, my
They
lord?
should not go for?
Fresh advertisement. So these interim orders are there, therefore the matter needs to be finally disposed of because I have also urgency, they have also urgency, my lord.
Let us see the termination order.
My lord, termination order, your lordship will find at page 69. Page 69, annexure 27.
Yes.
May I read it? To Messrs. Extra Freight forwarded, subject termination of lease. You were leased ECT on round trip basis by train number such and such for a period of 6 years with effect from 4/11/2022 to 3/11/2028 at per round trip freight of rupees such and such for 3 years with annual escalation of 10% of lump sum lease freight. However, despite many letters from this office to continue loading as per CA, you have continuously failed to load from 28/5/2023. Till now, you have missed loading on multiple instances like the dates are given by. Keeping in view the above, you have repeatedly violated para 11 and 5 of the contract agreement that your lordship will find at page 76. The competent authority has decided to take the following punitive action against you. Number 1, termination of lease contract number such and such dated 12/8/2022 of the PCET on round by train number such and such valid with effect from 4/11/2022 to 3/11/2028 for a period of 6 years with immediate effect. Number 2, cancellation of the registration certificate number such and such under category A leaseholder at Delhi Division of Northern Railway valid with effect from 2019 to 2024 and forfeiture of the registration fee. Accordingly, Delhi Division is hereby advised for forfeiture of the registration fee. Number 3, your firm is hereby debarred from fresh registration for a period of 5 years. Fresh registration will not be done by any division of the NF Railway in the name of Messrs. So-and-so for a period of 5 years. Outstanding dues of freight and demurrage charges amounting to 50 lakhs and odd is recovered from security deposit, and the rest balance security deposits is forfeited. Security deposit of 88 lakhs and odd is deposited by fixed deposit receipt number circumstances. So these are the actions. Now, if your lawsuit kindly comes to page 27 of the petition.
Yes.
My lord, the document starts at page 22. This is a, my lord, letter of acceptance for the tender. It starts at, my lord, page 22. Then, my lord, your lordship may skip to page 27, paragraph 25. Termination of contract. If it is not feasible to terminate the contract due to any reason, either the lease operator or railway administration can terminate the contract by giving 2 months notice. In such cases, security deposit shall not be forfeited. So, my lord, this notice was not given. This is, my lord, one of the contentions. But then, my lord, I will show that, my lord, they have allowed it earlier. In the instant case also, my lord, when we filed the application and, my lord, depending on the relevant rules, they had forwarded it. And, my lord, they had also taken no objection from the Eastern Railway. And along with that, my lord, they had gone to the railway board and rejected, my lord, rejected the.
Yes.
My lord. My lord, that termination, my lord, the shifting is permitted if the
I'm on that 2 months, 2 months notice.
2 months notice, my lord, regarding their paragraph 27, we have in our affidavit, we have stated in paragraph 20 of the affidavit, my lord. That repeatedly communicated to provide enough opportunity to perform the assigned responsibility. My lord, in our affidavit, page 108. Reply to pair 17, my lord.
108.
108 of the para 21.
Yes.
The petitioner repeatedly communicated and provided enough opportunity to perform his assigned responsibility as per the contract agreement. The petitioner has totally failed to operate the PCET. The railway authorities have finally terminated the contract that as per para 5 and 11 of the contract agreement signed by the petitioner Royman. So, my lord, now.
Where are you reading? Para?
5 and 11 in the contract.
I am reading para 20 of the affidavit.
Okay, of your affidavit, yes.
My affidavit, 108. There are 2 clauses in the contract agreement, my lord. Clause 5 and clause 11.
Yes.
Now, my lord may come the agreement, my lord. Clause 5 is at, my lord. Page 128.
Huh? Page
128, my lord. Contract agreement started page 124. Contract agreement started at 124. The relevant paragraph clause 5, recovery of railway dues is 128 minutes.
Mr. Counsel, please come to page 27.
Notice, my lord.
Huh?
Yes.
Yes. So where is the 2 months? Where is the 2 months notice?
That, my lord, yes. That our affidavit that part, my lord. Yes. And it's the 5. 23. One 74. My lord, last termination order is.
Let us see this 26/7/23. Page.
Page 62.
62. Malak, they have applied earlier for since it was allowed.
No, page 62 is not the thing.
Yes,
I'm talking about 26 July 2023. Annexure 26.
That is our appeal, my lord.
No. This is from Northeastern Frontier. Page 68.
Yes, 68, my lord. That is the final intimation. And the rejection of the request has no reason recorded. And if your lordship kindly gives me a few seconds to come to the my lord contract agreement, one clause, my lord, regarding change of terminals. Your lordship comes to page 129. That of the affidavit in opposition. That is a part of the contract agreement, clause 8 at page 129.
The termination is at what page?
Page 68, 69. In fact, my lord, the ends of law will be made, my lord, if the lordship satisfy this order and allow them to give the 2 months notice, maybe we will be able to satisfy them.
That's what I'm thinking. I'm not going into the other issue. The other issue.
Otherwise, my lord, I have to take your lordship to many documents, my lord.
That will be a problem.
My lord,
I'm only on this issue. You see, as per your contract agreement, 2 months' time is to be given.
once Malad, only one clause, Malad, page 139, kindly, Malad.
139.
This is also part of the contract agreement. Clause 27.
Yes,
Clause 27.
yes.
The right to terminate lease contract. Railway reserve the right to terminate contract without giving any notice at any time for whatsoever reason, as a punitive measure or breach of agreement by the leaseholder, or in case of operational accidents necessary to public interest. Such instances, the termination of contract by the railway administration should be followed by a written intimation of breach of contract within 3 working days of termination. However, in case of termination, this was also there. They are repeatedly requesting regarding Malad.
So, have you submitted a written intimation of breach of contract within 3 working days of the termination? Since you are relying upon this clause 27.
That Malad, repeatedly they are Malad.
Mr. Council, you are relying upon
Yes,
the provisions of your agreement and this, what is this?
contract agreement.
Huh?
Clause of the contract agreement.
Clause of the contract agreement. So this clause of the contract agreement 27 requires you to submit the within 3 days of the termination the reasons for breach of contract. I mean, the breach of contract committed by the petitioner. You have got to do that. Now, on both counts they have failed. What remains?
Only that is they are going to repeatedly, they are asking.
I agree. They might have done it 20,000 times. But then you are bound by your contract agreement or not? If you say that you're not bound, then why should he be bound?
That notice, yes, so I have to go by the correct one.
Right. Third, Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. P. Bhardwaj for the petitioner. Mr. K.K. Parasa, learned CGC appears for all the respondents. Acha. Acha, you take this, huh? Order dated 16/8/2023. I think Justice Manish's order is pretty, it'll help us. Para 2, 2.1, 2.2, 3, 4, huh? 4. Puस्तक. On perusing. No, first stuff, huh? The next page, huh? Where is that agreement? Page?
There is 124 of the affidavit.
Is it in operation, madam?
124. Okay, right. The agreement dated 25/11/22 executed between the parties at clause
Clause 11. He is relying on clause 11.
at clause 11. At no, wait.
No, in the work order, my lord, that 2 months condition is there.
Huh?
2 months condition is.
This is the work order.
My lord,
In the
that
work order.
means-
There is no agreement executed between the parties.
No, that is the work order.
The work order. So there is no agreement executed between the parties.
So this is the agreement.
Page?
124.
124 is the agreement, but the work order, my lord, there this condition appears. my lord.
Acha. Acha, okay. Wherever page, where is that work order?
Page 27. It starts at page
No,
22
just right. The
of the
the work order.
at the in the writ petition.
Cut that, huh? The work order
Starts at my lord page 22. Of the
dated 8/9/22,
8/9/2006.
which is annexure 1 to the writ petition, shows at serial number 25 that 2 months notice is required to be given by either the petitioner or the railway authorities prior to terminating the contract between the parties. Full stop. Clause 25 of the work order states as follows. Huh? This is at page 27. Then you come. Next para. This is agreement, no? The next one. This page 139.
139 is the agreement.
The agreement dated 25/11/22 executed by the parties at para 20 at clause 27 provides that the respondent railways have the right to terminate the contract without giving any notice at any time for whatever reason as a punitive measure or breach of agreement by the leaseholder or in case of operation exigencies, or it is necessary to do so in public interest. However, there is a subsequent condition to be fulfilled if the contract is terminated in terms of clause 27 of the agreement, comma, in as much as, comma, the railway administration has to issue a written intimation of breach of contract to the petitioner within 3 working days from the date of termination, from the date of termination of the contract. Next para. Rule 20, clause 27 of the agreement dated 25/11/22 is reproduced here and below as follows. Page 139. Okay. Next para. It is not denied by the parties that no notice, no prior 2 months notice was issued to the petitioner before the railway authorities terminated the contract between the parties. Further, while the railway authorities have the right to terminate a contract due to without giving any notice in terms of clause 27 of the agreement dated 25/11/22, comma, the railway authorities were to provide reasons in writing intimating the breach of contract on the part of the petitioner. However, the same also has not been done in the present case. Without going into the merits of the other issues raised by the petitioner, this court is of the view that the termination of the petitioner's contract, wide page, termination letter,
69.
wide letter dated 11/8/23 issued by the respondent number
Divisional Railway Engineer.
being in violation of the work order and the contract agreement executed by the parties, comma, is unsustainable. The same is accordingly set aside. However, there would be no bar on the respondents to take action for termination of the contract in terms of the work order, in terms of the conditions stipulated in the work order and the contract agreement executed by the parties, comma, if there are reasons to do so as per the terms and conditions stipulated in the work order and the contract agreement. The writ petitions accordingly disposed of. Enough?
Your Worship, may see, observe that the petitioner may continue with the contract. Petitioner may continue with the work. Termination already, no termination is stated, right?
So no, the petitioner may continue with the work, provided the same is allowed, provided no action is taken by the respondents for terminating the petitioner's contract.
Highly ordered.
No, that page you lost.
A timing
It's
item.
a timing matter.
Item?
Yes.
Item 20?
The issue involved in this writ petition is very small, my lord. And the
We have filed if it's not.
my lord, issue is very simple, my lord. GST, I have not annexed the GST with my tender document, my lord. And the terms of the contract says GST needed to be submitted if it is applicable.
Okay.
In my case, it is not applicable, my lord. But
Why not applicable?
because my GST Act says, my lord, where the turnover for a financial year exceeds 20 lakhs rupees, my
Okay.
lord. Only we are a small time, 40,000 my lord tender per year, my lord. This is so when it is 20 financial year exceeds 20 lakh rupees, then GST certificate necessary, my lord. In my case, the
Out here, what is is for settlement of a market?
settlement of a daily market.
And how much is your bid
My bid was, my lord, 65,000, my lord.
per month,
No, my lord,
per year,
per year, my lord. Per year, my
for
lord.
the entire period, 1 year?
Entire period, my lord.
Yes, madam.
1,01,000, my lord, 65,000, they have
Well,
settled.
So who has been selected?
My lord, 65,200, which below.
Who has been selected?
My lord, Pradeep Das, private respondent, my lord.
Number, respondent number?
Respondent number 5. 5, my lord. 4.
Is he here?
No, my lord, notice served, my lord, as per Rawajima report. He has not
Notice served.
appeared. My lord, page 22 is my bid value. Only that is my.
Yes. Why was he not selected?
Only that ground lordship, I have
That-
filed
what is the
affidavit
ground?
today, lordship.
Yes, let us see.
Uh, paragraph
Paragraph 6. Okay, so you are the L2.
Actually, valid bid because first, my lord, did not, my lord, submitted draft.
Yes.
That's why he is void ab initio.
And the one who is selected is the third highest. Third highest.
65,000, mine is 1 lakh, my lord.
He has submitted all the documents,
Yes,
lordship,
my lord.
including GST.
Has not submitted GST, so this goes.
Lordship, then go for test tender.
No, fine, fine.
Only
You
5
give it
months,
to him.
5 months left, my lord.
Okay, right. Third, Mr.
D. Sharma.
Huh?
D. Sharma.
D. Sharma,
Delhi.
learned counsel for the petitioner. Also heard Miss R.B. Bora, learned standing counsel for the BTC. That is respondents number 1, 2, and 3. No one appears for the respondent number 4. Even though the proceedings of the Lavazima court on 12/12/2023 states that the track consignment report available with the case record reveals that the notice in respect of the respondent number 4 has been delivered to the addressee on 21/10/2023. And as such, service is complete in respect of the respondent number 4. Pusta. Okay, then this order dated 20/09/23. You take this para 2. Okay. Next para, Miss R.B. Bora, the learned counsel for the BTC, submits that in terms of para 6 of the affidavit in the position filed by the respondent number 3, the petitioner's bid had not been accepted by the authorities as he did not submit his GST clearance certificate. I have heard the learned counsel for the parties. Where is the notice inviting tender?
Page, my lord, Translated copy, my lord, page 16. 16. 1/6, my lord.
Oh, I've got a meeting also. Oh, anyway, I've got 5 minutes now.
Page 18 about GST, my lord. Can you see? Roman.
Okay, I've heard the causes for the parties. The notice inviting tender dated 27/6/23. Page
Page 18.
provides
Page 18.
at clause number six
Roman.
bracket Roman
9.
9 that GST clearance certificate would have to be annexed to the bid documents if found necessary, if necessary. Yes, where is your act? The no section 22 bracket 1
Yes.
of the Central Goods and Services Tax Act 2017 provides that every supplier shall be liable to be registered under the GST Act in the state or union territory, other than special category states, from where he makes a taxable supply of goods or services or both, if his aggregate turnover in a financial year exceeds 20 lakh rupees. In the present case, there is nothing to show that the petitioner's annual aggregate turnover in a financial year is above 20 lakh rupees. In fact, the petitioner's bid value for the settlement of the market for one whole year
Yes.
is only 65,000.
No, my lord. 1,01,000.
At a 1,01,000.
Yes.
Next. In view of the above reason, the reason for disqualifying the petitioner's bid by the respondent authority is not sustainable and accordingly is set aside and not sustainable. Full stop. The petitioner would have to be considered. The petitioner's bid / tender would have to be considered by the authority for settlement of the market. Full stop. As his bid is 1,01,000 compared to the bid of the successful tender, that is respondent number 4, who had submitted a bid amount of rupees 65,200. The settlement of the market would have to be done by the state respondents in favor of the higher bidder. Consequently, the selection of the respondent number 4, which is the letter there?
Page
Order?
25, my lord.
Wide letter dated 2/8/23 bracket annexure 3, huh?
Yes, my lord.
As the successful bidder is hereby set aside. The respondents authority shall accordingly issue necessary orders for the remainder of the remainder period of the remainder period of the
Market.
remainder period of running the market within a period of 1 week from the date of receipt of a copy of this order. The petition is accordingly disposed.
All right.
I want to start to find difference.
Item?
31. There
Item
are
31.
Review petition, 8 petitions are.
Huh?
8 review petitions are there.
Item, you reply affidavit.
I want to give reply.
What is that?
That's your item.
Okay.
Interim order is there, my lord.
Huh?
Interim order
Yeah,
is there.
interim order will continue.
Interim order will continue. Mr. You're not there. Your name is not here.
SC Biswas, sir.
Okay, Mr. S.C. Biswas, legal counsel for the respondent.
Yes.
Respondent is granted
4 weeks time to file reply.
4 weeks.
But there are 8 petitions, that's why.
4 weeks time to file affidavit in reply. Mr. A.K. Datta appears for the petitioner. Oh, this is with regard to class 3 and class 2.
Yes, sir.
What is that? This is a question of law, Mr. Krishnan.
That's why we have to give a documentary evidence that we are not class. Or that
You are not class
Yes.
2.
Yes.
Okay, Mr. A.K. Datta appears for the state. This is the matter after
4 weeks.
4 weeks. Interim order to continue to the next day. Any interim orders?
What is
Huh?
number 9 I am making.
Item?
Response number 9, Lordship, that is.
In that case, okay, Mr.
RJ Talukder.
R.K. Taluda appears for point number 9.
Item 39, my lord.
Yes.
39 the motivation of the order of this honorable court, my lord. So matter may come on 5th of February, my lord.
Okay, this is the matter of 5th February.
Item 46, with regard to item number 48.
You take the thing. I've got a meeting at 4:30.
নাম show করার কথা করছি order আসতে হলে NIC ব্যাপার NIC